Did it last week too. It won't let it stay up.
Yes. Hello, I am Alexander Haig, and I'm now in charge.
All right. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Before we move into our markup today, with the concurrence of the ranking member, we will briefly open our hearing on Section 702 of the Foreign Intelligence Surveillance Act for purposes of voting to close the first witness panel in order to allow the committee to hear testimony regarding classified aspects of Section 702 of the Foreign Intelligence Surveillance Act, the disclosure of which would endanger national security if discussed in an open setting. This hearing will also feature testimony from a second panel of witnesses that will be open to the public. The question is whether the committee will close the first witness panel for our hearing on Section 702 to the public. Pursuant to House rules, a recorded vote is required, so the clerk will call the roll.
Mr. Chairman, point of parliamentary inquiry. Mr. Chairman, before taking this vote, is it appropriate to consider that there is a full house of people from the public who chose to come and therefore guide the process, that perhaps we take up the measures that can be debated in public before we move on to closing and sending everyone out of the room?
No, they're not going to have to leave. We're only going to vote to close the hearing
For tomorrow. Perfect. Thank you, Mr. Chairman. That's why I asked.
You want to say anything? Clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes yes. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes yes. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs?
Thank you.
Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu?
I don't want to have to come back after.
Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Wisconsin.
Mr. Sensenbrenner votes aye.
Gentleman from Texas.
Mr. Gomert votes aye.
Gentleman from Pennsylvania.
Mr. Marino votes aye.
The gentlewoman from California.
Ms. Bass votes aye.
Gentleman from Florida.
Mr. DeSantis votes aye.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 24 members voted aye, 0 members voted no.
The ayes have it. Tomorrow's first witness panel at our hearing on Section 702 will be closed to the public. And we hope that all future votes in the committee today will be of the same bipartisan nature. We now move back to our scheduled markup. And pursuant to notice, I now call up H.R. 372 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 372, to restore the application of federal antitrust laws to the business of health insurance to protect competition and consumers.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. Today, the health insurance industry finds itself in a great state of flux. Insurance providers, states, and the public have been dealing with the disastrous repercussions of Obamacare for the past 6 years and overregulation by states for much longer. After the Obama administration and its congressional allies forced through an unwieldy 2,700-plus page piece of legislation containing some of the most convoluted public policy in history, we are left today with health insurance markets besieged by dwindling competition and skyrocketing premiums. Minnesota Democratic Governor Mark Dayton recently said, "The Affordable Care Act is no longer affordable," quote unquote. President Clinton called Obamacare the craziest thing in the world. Premiums and deductibles have skyrocketed hundreds of % in some cases. Insurers are also fleeing the Obamacare health insurance exchanges. Health insurers have struggled to make a profit on the Obamacare exchanges since they opened in 2013. Aetna, Humana, and United Health Group abandoned some exchanges altogether in 2016. In 2017, the national state average of insurers participating in the exchanges dropped to 4, down from 6 in 2016. Some 21% of consumers returning to the exchanges will only have one carrier to choose from. 5 states, Alaska, Alabama, Oklahoma, South Carolina, and Wyoming, will only have one insurer providing plans on the federal exchange this year. In 2016, only Wyoming had a sole carrier. With rising premiums and providers scaling back their offerings, it is indisputable that Obamacare has forced the health insurance industry down the wrong path. As Congress works with the new administration on repealing and replacing Obamacare, all aspects of the industry, including the McCarran-Ferguson Act, are being evaluated. It is essential that we find a solution that encourages a robust and competitive health insurance market in which insurance providers actively compete for customers. Healthy competition ensures premiums are accurately priced and that customers are able to find a variety of policies to meet their specific needs and demands. H.R. 526, the Competitive Health Insurance Reform Act of 2017, calls for the repeal of the McCarran-Ferguson Act as it applies to the business of health insurance. There is wide support for this bill, and this committee has favorably reported similar legislation in the past, including legislation that was passed by the House 406 to 19 during the 111th Congress. The stated goal of the bill is to help restore competition in the healthcare market. I support this goal. However, I believe that any repeal of the McCarran-Ferguson Act must be coupled with larger changes to the existing healthcare regulatory scheme. Overregulation by states and the federal government has played a significant role in the high concentration and rising prices we see today in the health insurance market. All too often, it is only the large players that are able to navigate the web of rules and requirements forced on this industry. Moreover, we must ensure that a repeal of McCarran-Ferguson Act limits any disruption that would lead to higher concentration and reduced consumer choice. As such, we must protect the ability of insurers to continue pro-competitive, collaborative practices they have been able to engage in over the past 70 years. A little later, I will offer an amendment to do just that. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. And members of the committee, I support H.R. 372, the Competitive Health Insurance Reform Act, which repeals the antitrust exemption in the McCarran-Ferguson Act for the health insurance business. For many years, I've advocated for such a repeal, and you should know how pleased I am to see bipartisan support for this position. My own bill, H.R. 143, the Health Insurance Industry Anti-Enforcement Act, would similarly repeal the McCarran-Ferguson antitrust exemption for the health insurance business. It does so for price fixing, bid rigging, and market allocation, the most egregious kinds of anti-competitive conduct. Additionally, my legislation would repeal the exemption for the business of medical malpractice insurance, as this would be another key component of ensuring competition in healthcare markets. There are several reasons why Congress should repeal this antitrust exemption. To begin with, there's no justification for such a broad antitrust exemption for the business of health insurance. Congress passed the McCarran-Ferguson Act in response to a 1944 Supreme Court decision finding that the antitrust laws applied to the business of insurance. Both insurance companies and the states expressed concern about that decision. Insurance companies worried that it would jeopardize certain collective practices like joint rate setting and the pooling of historical data. And the states were concerned, on the other hand, about losing their authority to regulate and tax the business of insurance. To address these issues, McCarran-Ferguson provides that federal antitrust laws apply to the business of insurance only to the extent that it is not regulated by state law, which has resulted in a broad antitrust exemption. Industry and state revenue concerns, rather than the key goals of protecting competition and consumers, were the primary drivers of the act. In passing McCarran-Ferguson, however, Congress initially intended to provide only a temporary exemption and unfortunately gave little consideration to ensuring competition. Not surprisingly, 3 commissioners observed in the 2007 Antitrust Modernization Commission report that McCarran-Ferguson should be repealed because it has, quote, outlived any utility it may have had and should be repealed, end quotation. And another commissioner stated that the act is among the most ill-conceived and egregious examples of antitrust exemptions and that its repeal should not be delayed. Given the foregoing, I would encourage the committee to consider a full repeal of the McCarran-Ferguson antitrust exemption in the future. Antitrust exemptions should be exceedingly rare and should be enacted only where strong policy reasons support such exemptions. It is far from clear that McCarran-Ferguson antitrust exemption was ever fully justified, and while I support repealing that exemption for health insurance, it would be worth the committee's time to look beyond the health insurance sector. For example, my proposal would have also repealed the Act's antitrust exemption for medical malpractice insurers, given that a lack of competition among such insurers is one of the reasons for high medical malpractice premiums in the first place. And finally, repeal of McCarran-Ferguson exemption for the business of health insurance is a complement, not an alternative to the Affordable Care Act. Repealing McCarran-Ferguson alone will be insufficient to help patients and other healthcare consumers obtain affordable health insurance. We should remember that the House included language almost identical to H.R. 372 in its version of the Affordable Care Act. This is not an either-or situation. We need both measures to be in place to maximize benefits, improve quality, and lower prices for consumers. Nevertheless, I support this legislation and urge our committee to report it favorably. I thank you and yield back.
Thank you, Mr. Conyers. I now recognize myself for purposes of offering amendment. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 372. Strike all after the
Without
enacting
objection, the
clause.
amendment is considered as read, and I will now recognize myself to explain the amendment. The McCarran-Ferguson Act was originally passed to defer the regulation of the business of insurance to the states and to allow insurers to engage in certain pro-competitive collaborative activities. Has the amendment been distributed?
Is it being distributed? Apparently not.
Okay. For opening, wait a minute.
Let's continue with it.
I'll continue and then we'll recognize you after that. So the amendment should be before you at your desk. Today, such activities generally include the aggregation and sharing of historical loss data, the utilization of common forms, and joint underwriting for high-risk policies. The pooling of loss data, in particular, encourages accurate premium pricing for the benefit of consumers. Use of pooled data by smaller insurers allows them to accurately price coverage with resources they otherwise would not have available. Moreover, even larger insurers seeking to enter new states, markets, classes of business, or product lines depend upon industry-wide data that is available to them only because of the McCarran-Ferguson Act's limited exemption. Several proponents of the bill have asserted that federal antitrust laws have evolved since the passing of the McCarran-Ferguson Act and that the activities insurers are concerned with are no longer in violation based on well-established legal precedent. Despite the potential viability of this argument, if the McCarran-Ferguson Act is repealed, it will not stop parties, both private and federal, from testing the contours of such court-made doctrine. As a result, the health insurance industry would face significant uncertainty and likely disruption, with the consequences ultimately flowing down to the consumer. Absent certain safeguards, insurers may disengage from certain beneficial collaborative activities, eliminating or impeding smaller insurers from competing and disincentivizing larger insurers from exploring new products and markets. My amendment would codify the continued protection of these well-established pro-competitive activities. Specifically, the amendment provides safe harbors for the collection and distribution of historical loss data, the determination of a loss development factor, the performance of actuarial services that do not involve a restraint of trade, and the use of common forms that are not coercive. The insertion of these safe harbors will create a presumption that these pro-competitive activities can continue while still allowing regulation and oversight to the extent any activity crosses over into a restraint of trade. As a result, insurers will be encouraged to provide consumers with a diverse range of offerings at fair and reasonable prices. Importantly, this amendment does not seek to foreclose any other pre-existing judicial exemptions that have been developed over the years. Finally, this amendment removes other superfluous language and clarifies that the definition of property and casualty insurance includes insurance so classified by the states.
Mr. Chairman,
For purpose, the gentleman from Michigan seek recognition.
I rise in support of the substitute amendment.
The gentleman is recognized for 5 minutes.
Members of the committee, this substitute amendment preserves the underlying bill's basic effect, which is to repeal the antitrust exemption for the business of health insurance. The substitute amendment would add certain safe harbor provisions to clarify that the bill does not apply to certain collective activities common to insurance industry that courts have already found not to be anti-competitive, such as the pooling of historical loss data, the determination of a loss development factor applicable to historical loss data, the performance of actuarial services that do not involve a restraint of trade, or the development of a standard insurance policy form, as long as there's no agreement to adhere to or to require adherence to such standard form. The first three safe harbor provisions added by the substitute amendment were contained in a prior version of my own legislation, from the 111th Congress. The fourth safe harbor provision concerning the use of standard insurance policy forms codifies current law. The substitute amendment also includes definitions for the terms historical loss data and loss development factor taken from my earlier legislation. Consumer Union is written in support of the substitute amendment with the caveat that the committee should consider repealing the antitrust exemption further for hospital indemnity insurance and specific disease insurance. For these reasons, and because the substitute amendment preserves the effect of the underlying bill to repeal the antitrust exemption for the health insurance business, I am pleased to support the substitute amendment. And I yield back the balance of my time and thank the chair.
Chair thanks the gentleman. Would the gentleman from Rhode Island seek to give his opening statement this time?
Thank you, Mr. Chairman.
Gentleman who is the ranking member on the Subcommittee of Jurisdiction is recognized for his opening statement.
Thank you, Mr. Chairman. H.R. 372, the Competitive Health Insurance Reform Act of 2017, would repeal a longstanding antitrust exemption established by the McCarran-Ferguson Act with respect to the business of health insurance. This law was enacted more than 70 years ago in response to the Supreme Court's ruling in Southeastern Underwriters Association that insurance activity across state lines is commerce within the meaning of Article 1 of the Constitution and therefore subject to the antitrust laws. To qualify for the McCarran-Ferguson exemption, an insurer must be engaged in the business of insurance that is not designed to boycott, coerce, or intimidate and is regulated within a state. While these requirements somewhat constrain anti-competitive conduct, it is clear that they do not preclude the most egregious antitrust violations, such as price fixing, bid rigging, and market allocation by health insurance providers. In fact, Christine Varney, the former head of the Justice Department's Antitrust Division in the Obama administration, testified in 2009 that decades of case law demonstrate that this exemption immunizes these exact forms of unlawful conduct, even when they occur within our state regulatory schemes. Health insurance companies should be subject to antitrust liability to the extent that they collude or otherwise engage in anti-competitive behavior. H.R. 372 would provide for this result, and so I encourage our colleagues in the Senate to move quickly to adopt it or a similar measure. But let me be perfectly clear about two things. First, promoting competition in health insurance markets cannot occur at the expense of the strong protections established by the Affordable Care Act to make health insurance markets more efficient and prohibiting discriminatory insurance policies. These protections are textbook measures that help promote competition in the insurance market, as leading antitrust expert Professor Tim Grierney testified in 2015. Second, repealing McCarran-Ferguson antitrust exemption for health insurance will not automatically result in new pathways for insurance companies to compete and offer products across state lines, as President Trump and others have suggested. This simplistic approach to healthcare policy overlooks the fact that Section 1333 of the Affordable Care Act already allows states to establish healthcare choice compacts to provide for cross-state insurance sales. And according to the National Conference of State Legislatures, 5 states have already enacted out-of-state purchasing laws. But these laws have done little to encourage cross-state insurance sales because health insurers are simply uninterested in selling these products. The barriers to entry in health insurance markets are not truly regulatory. They are financial and they are network, as Professor Sabrina Cortlett of Georgetown University's Health Policy Institute has observed. In closing, I thank the Chair for consideration of this measure and Ranking Member Conyers for his steadfast leadership on this issue. I urge my colleagues to support H.R. 372, and with your permission, Mr. Chairman, I offer and ask for unanimous consent to put into the record a letter from the American Bar Association section of antitrust law supporting the full repeal of McCarran-Ferguson exemption.
Without objection, the gentleman's letter will be made part of the record. The question occurs on the amendment offered by the chair. Amendment to my amendment?
Mr. Chairman, I have
The
an
gentleman from
amendment to
Pennsylvania
desk.
seek recognition.
I have an amendment to the desk.
Clerk will report the amendment to the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 372 offered by Mr. Marino. Page 1, line 14, insert and limited scope dental benefits after insurance. Page 2, beginning on line
Without
11.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. I'll be very brief. I would like to introduce a short technical amendment to the substitute. This amendment will accomplish two things. First, it will clarify that the definition of dental insurance includes limited scope dental benefits and will be included in the scope of the repeal. Second, it makes a technical adjustment to the language of the standard form safe harbor to mirror the introductory language in the manager's amendment. And I yield back.
Chair thanks the gentleman. Question is on the amendment to the amendment in the nature of substitute. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the amendment to the amendment is agreed to. Now the question occurs on the underlying amendment offered by the chair. All those in favor respond by saying aye.
Aye.
Those opposed, no. And the chair, the ayes have it, and the amendment is agreed to. Are there other amendments to the amendment?
Chairman, may I have unanimous consent to put the letter of the Consumers Union dated February 28, 2017 into the record?
Without objection, it will be made a part of the record.
Thank you.
Reporting quorum being present, the question is on the motion to report the bill H.R. 372 as amended.
Chairman.
For what purpose the gentleman from Florida seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I wanted to make clear that I support this legislation as amended with your good amendment, but I did want to just clarify that I'm supporting it for the reasons that my colleague from Rhode Island, Mr. Cicilline, and the ranking member have expressed, and I wanted to just refer to something that you had said, Mr. Chairman, during your introduction of the bill when you referred to the disastrous implications of the Affordable Care Act. And I feel, Mr. Chairman, I feel compelled just to speak up since I have a constituent who's coming to town. She's not here yet, otherwise she wanted to be here for this hearing, but she's joining us tonight for the president's speech, and she's coming as the grandmother of a 2.5-year-old who, her grandson, was born blue and motionless, unable to breathe, unable to eat, unable to swallow, and after 2.5 years and more than $1 million spent in the first 4 months of life and hundreds of thousands of dollars since, her grandchild is still alive, and that likely would not be the case were it not for the Affordable Care Act that helped to provide the protections that ensure that that child received the care that was necessary. So on her behalf, I would reject the suggestion that the Affordable Care Act had a disastrous implication in this case. To the contrary, it would be the repeal of the Affordable Care Act that would have a disastrous implication on the life of this child. Moreover, Mr. Chairman, as we speak about disastrous implications of the repeal of the Affordable Care Act, they would extend not just to the grandchild of my constituent, but they would extend also to the 30 million people who would lose health insurance. They would also extend to the more than 50 million Medicare beneficiaries who would see their health care costs, their prescription drug costs go up. And, Mr. Chairman, I think too often forgotten, it would also mean that for the more than 150 million people who get their health insurance from their employers, every one of those policies now, as a result of the Affordable Care Act, it should be pointed out, no longer can include lifetime limits, annual limits, pre-existing conditions, discrimination against women. The policies can't be canceled when they're sick. The children can remain on their policies until they're 26. Mr. Chairman, I just wanted to be clear that when we speak of disastrous implications, that there is a very compelling argument to be made that, in fact, it is not the life-saving Affordable Care Act, as I described, certainly with respect to my constituent's grandchild and millions of others. It's not just that matters. It is the disastrous implications that would befall them and millions and millions of Americans if we repeal the Affordable Care Act, I know we will have a full debate on that very topic. Unlikely that we'll have it here, but I just felt compelled in light of your comment about disastrous implications that we be clear about what those disastrous implications might really be. Now you'll bet.
The chair will advise the audience that you are welcome to be present, but you are not welcome to participate in the debate. So restrain yourselves or you'll be asked to leave. A reporting quorum being present, the question is on the motion. It's not in order. We have passed the substitute amendment, and now we're on final passage. A reporting quorum being present, the question is on the motion to report the bill H.R. 372 as amended favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill as amended is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 1215 for purposes of markup and move that the committee report the bill favorably to the House.
Mr.
Clerk,
Chairman,
report the bill.
point of parliamentary inquiry.
Gentleman will state his inquiry.
Mr. Chairman, I would ask whether or not it is permissible to ask that H.Res. 111, the resolution of inquiry, be taken up first. My guess, and I don't want to be presumptuous, is that many people in the audience are here for that bill, and out of respect to the individuals who have joined us, I'd ask we take that bill up first.
I appreciate the gentleman's request. The committee has set forth its plan of procedure. All of these bills need to be reported today, so we're going to go ahead and proceed with H.R. 1215. Pursuant to notice, I now call up H.R. 1215 for purposes of markup. Move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1215, to improve patient access to healthcare services and provide improved medical care by reducing the excessive burden the liability system places on the healthcare delivery system.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. The bill before us today is modeled on California's highly successful litigation reforms that have lowered healthcare costs and made healthcare much more accessible to the people of that state. Because the evidence of the effects of those reforms on lowering health care costs is so overwhelming, the Congressional Budget Office has estimated that if the same reforms were applied at the federal level, they would save over $50 billion over a 10-year period. And because the evidence that those reforms increase access to health care is so overwhelming, they are supported by a huge variety of public safety and labor unions, community clinics, and health centers, and organizations dedicated to disease prevention, all of whom have seen the beneficial effects of these reforms in California. So popular are these reforms among the citizens of California that a ballot initiative to raise the damages cap, backed and funded by trial lawyers, was defeated by an over 2-to-1 margin in 2014. This bill's common sense reforms include a $250,000 cap on non-economic damages and limits on the contingency fees lawyers can charge. They allow courts to require periodic payments for future damages instead of lump sum awards, so bankruptcies in which plaintiffs would receive only pennies on the dollar can be prevented. And they include provisions creating a fair share rule by which damages are allocated fairly in direct proportion to fault. And this bill does all this without in any way limiting compensation for 100% of plaintiffs' economic losses, which include anything to which a receipt can be attached, including all medical costs, lost wages, future lost wages, rehabilitation costs, and any other economic out-of-pocket loss suffered as the result of a health care injury. Far from limiting deserved recoveries in California, these reforms have led to medical damages awards in deserving cases in the $80 and $90 million range. Unlike past iterations, this bill only applies to claims concerning the provision of goods or services for which coverage is provided in whole or in part via a federal program, subsidy, or tax benefit, giving it a clear federal nexus. Wherever federal policy affects the distribution of health care, there is a clear federal interest in reducing the costs of such federal policies. The legislation before us today also protects any state law that otherwise caps damages or provides greater protections that lower health care costs. When President Ronald Reagan established a special task force to study the need for federal tort reform, that task force concluded as follows. In sum, tort law appears to be a major cause of the insurance availability and affordability crisis which the federal government can and should address in a variety of sensible and appropriate ways. Indeed, the Reagan Task Force specifically recommended eliminate joint and several liability, provide for periodic payments of future economic damages, schedule, that is, limit contingency fees of attorneys, and limit non-economic damages to a fair and reasonable amount. All of these recommended reforms are part of the bill before us today. I urge my colleagues to support this legislation that would enact much-needed common sense and cost-saving litigation reforms that would increase health care accessibility for all.
Mr. Chairman.
Now my pleasure to recognize the ranking member of the Judiciary Committee, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman and members of the committee. Today's markup of 1215, the so-called Protecting Access to Care Act, is the 12th time since 1995 that we've considered legislation intended to deny victims of medical malpractice and defective medical products the ability to be made whole and to hold wrongdoers accountable. This measure has repeatedly failed because of its many problems, including its trampling of states' rights. But the majority seems now to be rushing it to markup as a part of their, what I describe, chaotic attempt to repeal the Affordable Care Act, even though it will directly impede Americans' access to safe, quality medical care. There are many problems with this bill. To begin with, H.R. 1215, like so many other civil justice bills we've considered, deeply intrudes on state sovereignty. Tort law is supposed to be the domain of states. Yet this bill preempts medical malpractice and product liability in many states. In particularly, H.R. 1215 preempts state law governing joint and several liability, the availability of damages, the ability to introduce evidence of collateral source benefits, attorney's fees, and periodic payments of future damages. Members should not be misled by assertions that the bill preserves state law. In truth, H.R. 1215 does nothing to address the fundamental concerns about states' rights previously raised by members on both sides of the aisle, as it intrudes just as deeply as its predecessor bills into areas traditionally determined by the states. In fact, the rule of construction expressly states that it preempts state law except in very limited circumstances where state law is more favorable to defendants. And a number of so-called state flexibility provisions simply reinforce one-way preemption where the bill supersedes state laws that are generally more favorable to victims, while leaving intact state laws that are more favorable to defendants. And further, this bill would cause real harm by severely limiting the ability of victims to be made whole. For instance, it imposes an unjustifiably low cap on non-economic damages. This bill's $250,000 aggregate limit for non-economic damages, an amount established more than 40 years ago, pursuant to a California statute would have particularly adverse impact on women, children, the poor, and other vulnerable members of society. These groups are more likely to receive non-economic damages in healthcare cases because they are less able to prove lost wages and other economic losses. Women, for example, are often paid at a lower rate than men, even for the same job, and are also more likely to suffer non-economic loss, such as disfigurement or loss of fertility. Imposing a severe limit on non-economic damages, therefore, hurts them disproportionately. Whatever the short-term savings, the bill would impose broad social and financial costs in the long term, including the additional strains on Medicare, on Medicaid, and other government programs caused when malpractice victims are denied full restitution. Finally, the bill unjustifiably provides blanket immunity for healthcare providers in medical product liability cases. Now, it's hard to know why a provider should be entitled to blanket immunity for dispensing a defective or dangerous pharmaceutical or medical device. This provision also has the potential to indirectly shield pharmaceutical and device manufacturers who may be able to argue successfully in a product liability action that a plaintiff's injury can be blamed on a provider's negligence. Because the provider would be immunized, the injured victim could be left without any recovery whatsoever. The law should not be used to create such an unjust result. And for these and other reasons that I don't have time to state now, I hope you will join me in strongly opposing H.R. 1215 and urge the Committee of the Judiciary to reject it. Thank you, Mr. Chairman.
Thank you, Mr. Conyers. It's now my pleasure to recognize the Chairman of the Subcommittee on the Constitution and Civil Justice, Mr. King of Iowa, for his statement.
Thank you, Mr. Chairman. I rise in support of H.R. 1215, and I'd like to discuss the need for this bill to preserve fiscal sanity and federal health policy. As reported in the Washington Post last week, U.S. health care spending is projected to accelerate over the next decade. A study by the Centers for Medicare and Medicaid Services projects that the average growth in health spending will be even faster between 2016 and 2025. The projections are based on an assumption that the legislative status quo will prevail. That means if we don't do anything. As Nate Silvers pointed out in the New York Times, quote, all of the major categories of federal government spending have been increasing relative to inflation. But essentially, all of the increase in spending relative to economic growth and the potential tax base has come from entitlement programs, and about half of that has come from health care entitlements specifically, close quote. So as health care costs rise, wages fall. As the more companies must pay in health care costs, the less they can pay in wages. I mean, just take a look at the chart up there that's published at the Journal of the American Medical Association. This chart shows the top line, the growth in health care costs on the top line with the round buttons, and the bottom line with the triangles shows the growth in wages. The chart shows that when health care cost growth slows, wages go up, but as health care cost growth increases, wages stagnate. And when health care costs grew at a slower rate, as they did in the mid-2000s, wages rebound again. If you want to increase wages, vote for this bill, because one of the drivers of higher health care spending is defensive medicine. It's a very real phenomenon confirmed by countless studies in which healthcare workers conduct many additional costly tests and procedures with no medical value that are charged to the federal taxpayers and to other consumers simply to avoid excessive litigation costs. A survey published in the Archives of in the Archives of Internal Medicine found that 91% of the over 1,000 doctors surveyed reported believing that physicians order more tests and procedures than needed to protect themselves from malpractice suits. The survey also asked, quote, are protections against unwarranted malpractice lawsuits needed to decrease the unnecessary use of diagnostic tests, close quote. And overall, the same 91% of doctors surveyed agreed. One Newsweek reporter described the personal experience of individual doctors this way. Typical was one doctor who had a list as long as my arm of procedures ER docs perform for no patient benefit. They include following a bedside sonogram with an, quote, official sonogram, because it's easier to defend yourself to a jury if you've ordered the second sonogram. A CT scan for every child who bumped his head or her head to rule out things that can be diagnosed just fine by observation. X-rays that do not guide treatment, such as for a simple broken arm, or CT scans for suspected appendicitis that has been perfectly well diagnosed without it. In fact, I have an orthopedic surgeon who said to me that when he has a knee injury, 97% of the tests that he orders are protection for malpractice. He knows what he's going to operate on before he actually starts the surgery. So although doctors may hate practicing defensive medicine, they do it so they don't get sued. Nationwide, physicians estimate that 35% of diagnostic tests they ordered were to avoid lawsuits, as were 19% of hospitalizations, 14% of prescriptions, and 8% of surgeries. All told, it adds up to $650 billion in unnecessary care every year. Another ER doctor said he ordered 52 CT scans in one 12-hour shift. That's $104,000 in one day. I'd like to own that machine. The more recent study, publishing a few months ago in the Journal of the American College of Radiology, studied the effects of tort reform on just radiographic tests alone and found that there were, quote, 2.4 million to 2.7 million fewer radiographic tests annually attributed to tort reforms, close quote. Just imagine what savings would occur if such reforms were attached to all federal health care programs, as this bill would do. I urge all my colleagues to join me in supporting this vital legislation, and I would also say in response to the trampling of states' rights, that this bill goes a long ways to respect states' rights and gives the states the authority to raise or lower the cap for non-economic damages out of respect for states' rights. And also, I'd point out that it models legislation that began in California, signed by by Governor then and Governor now Jerry Brown. I'm amazed to be advocating for such a policy, but I'm also impressed by the policy and the progress that has been made in the state of California. Let's spread that to the rest of America today, and I yield back.
The chair thanks the gentleman. The chair is now pleased to recognize the ranking member of the Subcommittee on the Constitution and Civil Justice, the gentleman from Tennessee, Mr. Cohen. 5 minutes.
Thank you, Mr. Chair. I appreciated Mr. Deutsch's comments about the Affordable Care Act, Patient Protection Act, and the dangers that we could see if we repeal it. And then the chairman in his statement quoted my friend Bill Clinton with some political campaign rhetoric that Bill Clinton engaged in. But he forgot to mention John Boehner, who said that basically the Republicans are going to fix the flaws on this law and put a more conservative box around it, saying it's repeal and replacement of Obamacare is not going to happen. That's reality. And while I understand that the chairman calling it Obamacare is using a sobriquet that has been applied to that law, and we don't have rules that prohibit us from saying things that might use a name of a president, that's kind of dog whistle politics. We know what that's about. It's the Affordable Care Act and Patient Protection Act. It's not Obamacare, which was an appellation given by people of the other party to try to draw attention to folks that didn't like that president. So I find that a little bit difficult when we're trying to deal with an issue that's of importance and we get into political dog whistling. Medical malpractice has always been the province of the states, and no matter how you spin it, and if you say something about Jerry Brown and how wonderful it was, Jerry Brown did it in California. California is a state, and this is a state issue. And this Congress, which long the majority has been for states' rights, except, of course, when it comes to issues concerning guns and gun licenses, and apparently some other areas like marijuana, it not being a state issue. This is a state issue. And the wonderful thing about states having different laws is what Justice Brandeis said about states are the laboratories of democracy. Each state can do things in different ways, and the states can look and see what happened when they did it, and then we can learn. And one size fits all takes away that possibility. This particular bill comes up at a time when there are serious issues going on in America that threaten, in my opinion, Mr. Chairman, the core of democracy. To accuse the press of being the enemies of the people, a statement that even Nikita Khrushchev veered away from in the 50s because even that was too much in a communist country and for that particular communist leader. It smacks of against the First Amendment, and our previous president and our penultimate president, I guess, which is where it's going. I miss Barack. I even miss W. President Bush, George W. Bush, just said the other day that power, in essence, corrupts and there needs to be controls over it, and that the press is an important and indispensable part of democracy and certainly not the enemy of the people. Jewish cemeteries are being desecrated in St. Louis and in Philadelphia, and Jewish community centers are being threatened on a daily basis, it appears. Anti-Semitism and racism and the shooting of two Indian individuals and Indian nationals, one of whom was murdered in Kansas by an individual who thought they were from different and they shouldn't be in America, are alarming. And these are issues we should be strongly concerned about. And if we want to make health care cheaper, which we should, and make it more affordable, we ought to have a single-payer system.
Yes.
That would make it more affordable. And if that's the nexus that makes this law applicable for the federal government to usurp the states, and the chairman said the nexus was that it makes things cheaper, and when anything makes health care cheaper is so important that we need to take it away from the states. Well, if you're concerned about cost, you should be for a single-payer system, and that would make it cheaper and take profits away from insurance companies that right now are paying for ads to get people to buy drugs and making immense profits and having their executives draw salaries in the areas of $40 and $50 million. This bill takes away from people who are hurt by medical malpractice in ways that are artificial and wrong, and we should not be on the side of those people who commit medical malpractice and cause injuries to others. With all of that said, I respectfully suggest that the agenda we're following is not the agenda of the American people at the present time, and it's the agenda of the American Medical Association, who's here today, and this is the bill du jour. I yield back the balance of my time.
Chair thanks the gentleman, and I now recognize Mr. King of Iowa for purposes of offering an amendment.
Thank you, Mr. Chairman. I have an amendment at the desk in the nature of a substitute.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1215 offered by Mr. King. Strike all that follows after the
Without
enacting
objection, the
clause.
amendment will be considered as read, and I will now recognize Mr. King to explain his amendment.
Thank you, Mr. Chairman. This amendment in the nature of a substitute, it's the same text as the bill was introduced, minus, so the amendment in the substitute leaves out the non-operative portions of the bill, meaning specifically the findings and the purpose. And I would urge its adoption and yield back the balance of my time.
Chair thanks the gentleman. For purposes the gentleman from Michigan seek recognition.
Mr. Chairman, I rise in opposition to the substitute amendment.
Gentleman is recognized for 5 minutes.
Ladies and gentlemen of the committee, the substitute amendment appears to make no substantive changes to the underlying bill and simply removes the findings and purpose section of the bill as introduced. Therefore, I oppose the substitute amendment for the reasons I've already previously outlined in my opening remarks, and hope that the majority of members of this committee will join with me. And I yield back the balance of my time, and thank you.
Question occurs on the amendment offered by the gentleman from Iowa, Mr. King. All those in favor respond by saying aye. Aye. Those opposed, no.
Oh, no. Wait a minute.
Okay.
We haven't.
We will withdraw that vote, and
thank
we
the
will
chair.
ask if there are any amendments to the amendment.
I have an amendment to the amendment.
The clerk will report the amendment of the gentleman from Michigan.
Amendment to the amendment in the nature of a substitute to H.R. 1215 offered by Mr. Conyers of Michigan. Page 12, line 7, insert after "or local government" the following, which alleges an intentional tort.
The gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, I first want to thank you for your forbearance and allowing me to introduce this amendment. This amendment, members of the committee, address to me one of the worst shortcomings in the bill by exempting actions alleging intentional torts from the bill's scope. Intentional torts. While many people think of negligent conduct when considering medical malpractice or products liability cases, we tend to forget that the most egregious torts are intentional torts. Intentional torts happen when a person deliberately harms a victim. The harm was not the result of an accident, but of a deliberate act by the wrongdoer done with intent to harm the victim. Examples of intentional torts include assault, battery, rape, conversion, false imprisonment, intentional infliction of emotional distress, fraud, representation, malicious prosecution, abuse of process, invasion of privacy, and defamation. As currently drafted, H.R. 1215 would equally apply to those who commit those heinous acts as well as those who merely commit a negligent act. For example, the bill would cap non-economic damages at $250,000. Such a limit, as I noted earlier, is based on a dollar amount set in a California statute in 1975, an amount today woefully insufficient to compensate a victim of intentional torts, which are some of the most egregious kinds of conduct over which to sue. The bill also eliminates joint and several liability, making it more difficult to hold multiple wrongdoers accountable. It also imposes an unreasonable statute of limitations and severely limits attorney fee arrangements, which may effectively deny many victims access to the court. These concerns are even more heightened when we're talking about intentional torts. For example, earlier this month, Dr. Christopher Dunch, a Texas neurosurgeon, was convicted of a felony charge of injury to an elderly person in a case where prosecutors alleged that he deliberately maimed up to 15 of his elderly patients, at least 2 of whom died as a result of his acts. In 2011, Dr. Earl Bradley, a Delaware pediatrician, was convicted and sentenced to 165 years in prison for 471 counts of child sexual abuse after he molested 103 of his patients, all minors. Dr. David Fuster, a Maryland dentist, was found guilty of raping a 15-year-old girl whom he had drugged with nitrous oxide. 5 other women came forward with similar allegations. GlaxoSmithKline knowingly sold 20 drugs of questionable safety that were made at a plant in Puerto Rico that was rife with contamination. The plant was eventually closed in 2009. Examples of such intentional conduct abound in the healthcare industry. And yet H.R. 1215 would severely limit what victims could recover for these wrongs and could even deny them their day in court. And so my amendment would not fix the fundamental flaws in H.R. 1215, but it would make a terrible bill just a shade better by providing victims of the most egregious kinds of conduct, like sexual assault, some measure of justice accordingly. And for those reasons, I urge my colleagues to support this amendment. I thank the chairman and yield back the balance of my time.
Chair, thanks. Gentlemen, for purposes, the gentleman from Iowa seek recognition.
Mr. Chairman, I seek to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in opposition to the Conyers amendment. This amendment should be defeated. And Black's Law Dictionary defines intentional tort as a tort committed by someone acting with general or specific intent. It means a doctor who takes any specific action is acting with specific intent to take that action. And so this amendment, if adopted, the effect of it would be to gut the bill. Any hostile judge, and we have seen many of them, especially recently, who opposes the policy of this bill, could use the phrase this amendment would insert into the bill to entirely negate the bill itself. And that phrase that is entered in is which alleges an intentional tort. And so I urge all of my colleagues to oppose it, and I would point out also that the concern that the ranking member from Detroit, from Michigan, Mr. Conyers, raised that the bill would cap non-economic damages at $250,000 being unreasonable. That is the law in California today. And the economic damages themselves they are allowed to go fully in this bill to make a person whole if they are damaged, if they have a legitimate tort claim, whatever the price is to them to make them whole, and then allow also for the non-economic damages to go to them under the cap to send the message. But this allows, the bill itself allows each state to set that cap if they disagree with the federal cap that would be in this bill. I think it's a prudent way to craft this. This bill is drafted with respect towards states' rights. It's carefully put together. And this amendment offered by the gentleman from Michigan, the effect of it would be to gut the bill itself. And so I urge that we vote down the Conyers amendment, and I yield back the balance of my time.
The question occurs on the amendment offered by someone seeking recognition?
Yes, Mr. Chairman, I move to strike last word.
Gentleman from Maryland is recognized for 5 minutes.
Mr. Chairman, thank you very much. I rise in favor of the Conyers amendment. The bill generally is a massive assault on the power and the right of states to set up their own tort systems. In Maryland, for example, our caps are $785,000, which was arrived at after a very long and complicated series of compromises and discussions between the plaintiffs' bar and victims' groups, the hospitals and the doctors, and this bill would just take a sledgehammer to our whole tort system. And I think before any member of this committee thinks about voting for this legislation, you should check what your own state laws are, because far from respecting federalism and state rights, the legislation is a bulldozer and puts all of us in a straitjacket imposed with very low caps, $250,000. It would also abolish joint and several liability, which is something else that my state has, which basically shifts to the tortfeasors the responsibility of sorting out who's at fault and who's got to pay what, instead of putting that on the victims of toxic torts or intentional torts. Now, as to the amendment, it would make a very egregious bill a little bit better by carving out from its provisions the victims of the most severe kinds of intentional misconduct, like sexual assault by doctors or dentists against their patients while they're sleeping. There is I just beg to differ with my distinguished colleague who just spoke. There's a vast difference between intentional torts, where the person sets out deliberately to do harm, and those torts that occur as a matter of negligence, falling below a general standard of good behavior in a field, or strict liability, which is what we impose upon the producers of mass products, for example. So all that the ranking member is saying here is, at least in the case where you've got a deliberate tortfeasor, someone who sets out to assault someone else, someone who sets out to sexually assault or rape someone else, someone who sets out to inflict harm, we should not be imposing this straitjacket of pro-defendant rules on the states. And so I feel very strongly that we need to adopt this amendment at the very least. And with that, I'll yield back the remainder of my time, Mr. Chairman.
The question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. The amendment
Could we have a record vote,
A
sir?
recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Florida.
Mr. Gates votes no.
Gentleman from Texas. The gentlewoman
Gomert
from
votes no.
Alabama.
Ms. Roby votes no.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 12 members voted aye, 16 members voted no.
And the amendment is not agreed to. For what purpose the gentleman from New York seek recognition? Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I won't take 5 minutes. Mr. Chairman, we have considered this bill many times in the past. It is as obnoxious today as it has been in the past when it was reported to the floor by party line votes. In the past, I have offered 2 amendments, which I'm not going to offer today. I just want to mention them. The bill limits non-economic damages, pain and suffering and so forth, to $250,000. This is based on the California law, which the chairman referenced in his opening remarks, which established a $250,000 cap back in 1976. There's been inflation since 1976. $250,000 since 1976. $250,000 in 1976 is considerably less today. And if they figured that that was an appropriate amount then, it's no longer an appropriate amount. So I've offered 2 amendments. One, to change the $250,000 to $1.5 million or something like that, which is the equivalent today, and the majority has voted that down in the past. I've also offered an amendment to index the $250,000 if we must pass that, so that it remains $250,000 in real terms in the future and doesn't inflate down to nothing. Those are still good amendments. They would still make an obnoxious law only slightly less obnoxious, because this is a bulldozer through plaintiffs' rights. I'm not going to offer these amendments now in the interest of saving time, since many people are here waiting for H.Res. 111, the resolution of inquiry. The chair has insisted that that be placed last on the agenda. This bill may take a couple of hours or more or less, and I do think we should get to the resolution as soon as possible. And so in the interest of saving time for that purpose, I'm not going to offer these 2 amendments, which I know would be voted down on party line votes anyway, but they're still worthy, and I commend them to the attention of everyone. And I yield back.
Purpose of the gentleman from Tennessee seek recognition.
To offer an amendment.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1215 offered by Mr. Cohen. Page 12, line 7.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chair. This amendment would exempt from the bill all cases concerning A, the provision of goods and services resulting in a foreign object being left within the body of the person to whom such goods or services were provided. A foreign object being left in the body. And B, the performance of a medical procedure on the wrong person or the wrong body part. Patients who are injured by such misconduct should not be subject to the cap of $250,000 on non-economic damages. Significantly reduce their ability to fully recover damages or possibly have their suit completely barred, as H.R. 1215 would do in some circumstances. According to the Joint Commission Center for Transforming Healthcare, a hospital accrediting agency, wrong site and wrong patient procedures occur more than 40 times each week in the United States. As if that were not disconcerting enough, the Journal of the American Medical Association reports there are 1,500 incidents of surgical tools, aka foreign objects, being left in patients each year, which can lead to pain, infection, complications, longer hospital stays, additional surgeries, and sometimes death. Incidents of wrong patient and wrong site surgeries or foreign objects being left inside a patient greatly heighten the risk of serious injury and death. Yet H.R. 1215 would impose numerous obstacles that could prevent victims of such egregious medical malpractice or even intentional misconduct from being compensated for what could be lifelong injuries. For instance, its extremely low cap on non-economic damages will prevent many victims from being fully compensated for these injuries. Women, children, the poor, the elderly, and disabled will be particularly hurt by H.R. 1215's cap on non-economic damages, as members of these vulnerable groups are more likely not to have significant lost wages or other kinds of economic loss. Similarly, by eliminating joint and several liability, H.R. 1215 will make it harder for injured patients to be fully compensated for their losses, potentially allowing some wrongdoers to escape liability. Finally, the bill immunizes healthcare providers from lawsuits arising from the dispensing or prescription of defective or dangerous medical products that are approved by the FDA. This shuts the courthouse door to many victims of medical malpractice and defective products. My concern about wrong patient, wrong site injuries are not hypothetical in any way whatsoever. Comedian Dana Carvey sued his heart surgeon for $7.5 million after the surgeon had performed open heart bypass surgery on one of his completely healthy arteries rather than his diseased artery. Mr. Willie King of Florida received $1.2 million settlement from a hospital after a surgeon amputated both of his legs rather than just the one diseased leg. Miss Molly Akers of Illinois had an unnecessary mastectomy performed on her after her doctors switched her biopsy results with another patient's, which not only left her disfigured but also delayed a potentially life-saving procedure for the other patient. Horror stories like these abound, yet if H.R. 1215 had been in effect, none of these people may have even been able to have their day in court, much less receive the amount of compensation they did for serious injuries they suffered as a result of the negligence of healthcare providers. This one-size-fits-all save money, despite the fact that some are subject to horrific losses and damages, is wrong. For these reasons, I urge the committee to adopt the amendment and to see to it that people who have legs amputated, that were not the leg to be amputated, limbs of any kind removed that weren't supposed to be removed, or surgeries performed on them that weren't supposed to be compensated, and they be exempted from this law. Thank you, sir.
What purpose does the gentleman from Iowa seek recognition?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. And first, I'd like to say there's nothing in this bill that prevents this litigation under the bill from making a patient whole. And this amendment, though, should be defeated, as if the intention is to reduce medical errors, then this amendment should be defeated and the base bill should be passed. The litigation reforms in this bill, the Protecting Access to Care Act, will reduce the incidence of medical malpractice because the threat of potentially infinite liability in an unregulated tort system prevents doctors from discussing medical errors and looking for ways to improve the delivery of health care. The Protecting Access to Care Act would largely dispel that fear and allow doctors to freely suggest improvements in medical care. The medical journal Annals of Medicine reported in an editorial that the medical profession, for reasons that include liability issues, was not harnessing the full power of errors to teach and thereby reduce errors. Close quote. A survey conducted for the bipartisan legal reform organization named Common Good, whose board of advisors included former Senator George McGovern, Eric Holder himself, and former Senator Paul Simon, found that more than 3/4 of physicians feel that concern about malpractice litigation has hurt their ability to provide quality care in recent years. When physicians were asked, generally speaking, how much do you think that fear of liability discourages medical professionals from openly discussing and thinking of ways to reduce medical errors? To that question, an astonishing 59% of physicians replied, a lot. Indeed, according to an exhaustive study by the RAND Corporation, California's reduction in the number of healthcare lawsuits filed in that state is attributable to improved patient safety at California hospitals. According to that study, our results, and I quote from the study, our results showed a highly significant correlation between the frequency of adverse events, meaning medical errors, and malpractice claims. On average, a county that shows a decrease of 10 adverse events in a given year would also see a decrease of 3.7 malpractice claims. Likewise, a county that shows an increase of 10 adverse events in a given year would also see on average, an increase of 3.7 malpractice claims, directly correlated. According to the statistical analysis, nearly 3/4 of the within-county variation in annual malpractice claims could be accounted for by the changes in patient safety outcomes. We also found that the correlation held true when we conducted similar analyses for medical specialties, specifically for surgeons, non-surgical physicians, obstetricians, gynecologists. Nearly 2/3 of the variations in malpractice claiming against surgeons and non-surgeons can be explained by changes in safety rules. The association is weaker for OBGYNs, but still significant. With the passage of healthcare lawsuit reform in California, doctors, hospitals, and other healthcare providers are able to share information needed to create a safer environment without fear of lawsuits and focus on their patients instead of worrying about getting sued. The same should apply nationwide to reduce medical errors nationwide. And I would reflect that some time back, a year and a half ago, I sat down with Captain Sully, who landed that plane on the Hudson River with utter safety and saved all the passengers involved in that plane. He and an Air Force general and I had dinner, and they talked through what they do when there is a plane crash. The first thing they do is they throw blame out the window, and then they examine every chain along the chain of events that led up to that tragic crash, or in this case, a happy ending to what otherwise would have been a tragic crash. And with blame out the window, and with liability not a consideration, then they repair not just the link that broke in the chain, but also they repair every weak link. And they said, because if we don't do that, then the next weak link will break. And they wanted to take that experience they have with airplane crashes and apply it to the medical industry, and they asserted that there would be billions of dollars saved because of mistakes made in medical services and providers, because they don't have that opportunity to examine every link in the chain out of fear of massive malpractice suits. So this point that I make here in opposition to the gentleman's amendment hits home clearly, and I think we should apply the FAAs to the medical side of this thing, and it would save lives and it would save billions of dollars. So
Will the gentleman yield?
I would yield.
Does Captain Soley support this legislation? I only ask because he lives in Danville.
In reclaiming my
which I
time, that would be irrelevant, but in fact, I doubt that if he's paying attention to us today, he's doing other great things for America. Thank you, and I'd yield back the balance of my time.
Mr. Chairman.
For what purpose does the gentlewoman from Washington seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlewoman is recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in strong support of this amendment by my colleague, Mr. Cohen, and I thank him for putting forward a very compassionate measure to ensure that injured patients and their family members can pursue justice rather than be limited by a number that undervalues their health. Make no mistake, Mr. Chairman, that this bill puts the interests of big corporations over everyday people. It does not just limit the ability of injured patients and families to hold healthcare and medical providers accountable, it also prevents them from taking action against drug and medical manufacturers, pharmaceutical companies, insurance providers, nursing homes, and others. And it is simply not true that it would assist us in reducing healthcare costs. In fact, according to a 2016 study by researchers at Northwestern University and the University of Illinois, malpractice caps contained in this bill hurt healthcare spending. Instead of reducing healthcare costs, caps resulted in a 4 to 5% increase in physician service spending. The researchers concluded that the evidence simply did not indicate that malpractice caps reduce healthcare spending. My home state, the state of Washington, is one of 11 states where our Supreme Court has struck down statutorily enacted medical malpractice damage caps as unconstitutional. And this bill intrudes on our state's ability to implement our constitutional protections. This bill and the caps that it imposes send a signal to medical and healthcare providers that they can act irresponsibly, perhaps to make more money and get away with it. There have been numerous cases that demonstrate this, and I feel compelled to bring up a very recent case in my home state of Washington, specifically with the neurology program at Swedish Cherry Hill Hospital in Seattle, which came under fire because of negligent care arising out of a program designed to incentivize neuroscience doctors to take heavy caseloads of complicated cases. According to data collected by the federal government, that hospital was flagged for having high rates of blood clots, collapsed lungs, and serious surgical complications. And during the last few years, state data indicate that problem indicators like aneurysm patients with high numbers of strokes has increased, with surgeons requiring patients to undergo invasive surgeries that require opening a patient's skull and working on the brain where less invasive technologies are available. The motivation for all of this, billions of dollars in profit. Ultimately, the high volume of cases resulted in serious errors. According to the Seattle Times report again, one patient, Jeff Sproles, who was a Marine Corps veteran, experienced trouble breathing and swallowing after a surgery that the doctor claimed was so simple he could do it with his eyes closed. And he later found out that the surgeon had actually messed up the operation, and as a result, he spent months recovering and had to be fed through a tube in his stomach. After the Seattle Times contacted Mr. Sproles about his case, he requested his medical records and learned that a fellow was involved in the surgery. The records did not clearly indicate how much time the original doctor spent on the procedure or how much time he spent in the operating room. In another case at the same facility, a talented and vibrant young woman named Talia Goldberg went in for cervical spinal fusion from a neurosurgeon who's been embroiled in numerous investigations, and she ended up dying. According to the Seattle Times investigation, numerous problems surfaced around her care or lack thereof, and attention to the surgery and the medical complications that arose for it. I found this specific quote about Talia that was in the newspaper particularly painful and moving. As she went in for the surgery, she was talking about what it might feel like for her to be able to once again resume her activities, and she wrote this: "So who am I? I am an artist, a dreamer. I am a stationary biker. I am a woman, a girl, a person. I am a skier. I am an aspiring pole vaulter. I am a reluctant yet faithful believer in the power of lucky underwear. I am a someone with a voice. I want people like Jeff Sproles and the family of Talia Goldberg to know that we in Congress have their back. And rather than protecting patients, rather than protecting medical providers and pharmaceutical companies, we should be protecting patients. It is ill-conceived that we are considering this bill, and I hope my colleagues will join up in speaking for real people with real injuries by opposing this bill. I yield back. Thank you, Mr. Chairman.
Mr. Chairman.
Wait, what purpose does the gentleman from Maryland seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
I want to rise in favor also of the amendment and echo the sentiments of my distinguished colleague from Washington State. We are invited by our distinguished colleague from Iowa to throw blame out the window and to get rid of blame because this will apparently incentivize the hospitals and the doctors to get to the bottom of the issue. Well, what we call in the moral context blame is what we call in the legal context responsibility. And if somebody is injured because a medical tool is left in their body during surgery, they're injured. And profoundly so, there are medical costs to that, there are costs to their ability to make money, to support their families, and so on. Again, the states have tried to deal with this problem with their own tort system. This legislation proposes to take a sledgehammer to all of it and replace 50 state solutions across the country that our constituents and our state legislators have worked on with one-size-fits-all quasi-solution without even a hearing on the bill. That's what they're proposing right now. But on this blame question, we need to assign responsibility. Under this legislation, if there's an intentional hijacking of an airplane, to take the gentleman's example, tort liability would be limited to the extremely stringent caps that are put in here because we just rejected the gentleman's amendment to carve out intentional torts from it. So we need to have legal responsibility as the cardinal principle of the law. Now, I'm not impervious to the gentleman's argument that we want doctors and hospitals to be able to talk about systemic malfunctions, but since we haven't had a hearing, I have no idea to believe what he's saying, which is that if we shut down the tort system in this way, we're going to get more honesty and discussion and transparency in the hospital system. Logically speaking, I would say the counter is far more likely to be true, that if the truth comes out through the discovery process and what happens in court, we'll be able to examine what the real problems were, what the real flaws were. However, if you shut down the tort system and you make it just a cost of doing business, you can throw a couple $100,000 in somebody's direction, you'll be able to cover the whole thing up. And so I am not persuaded by that argument. Again, Mr. Chairman, I renew the criticism I've been making, I think, since I got here, which is that we've not had a hearing on this bill. I appreciate the fact that some members may have heard a bill several years ago about it, but that's not the case for at least 9 of us who are new to the committee, and nothing that I've heard would suggest that we should be supporting the underlying legislation, and we very much do need the gentleman's amendment. And with that, I yield the remainder of my time.
First, the gentleman from Florida seek recognition.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I support Mr. Cohen's amendment, and I wanted to address just the general way in which we're talking about this legislation and the civil justice system. Because the fact is, suggesting that we throw blame out the window is a total mischaracterization of the way the civil justice system works in America. We cast blame. That's what it does. Judges and juries listen to the evidence, and then they make a ruling. If my friends who support this bill didn't believe that, didn't acknowledge that, they wouldn't keep referring to the language about, well, it provides an unlimited amount of damages for actual economic losses. If I can just refer, I brought out Black's Law Dictionary, but I thought it more appropriate to refer to the definitions that the American College of Surgeons uses. Economic damages refers to compensation for objectively verifiable monetary losses such as past and future medical expenses, loss of past and future earnings, loss and use of property, cost of repair, replacement, economic value, domestic services, etc. How much money do you lose by not being able to work after malpractice was committed? What's the economic loss? Non-economic damages, which, by the way, if you believed there was no place for blame, there would be no place for damages of any kind. But obviously there is, because that's our system, and non-economic damages refer to compensation, and I quote the American College of Surgeons, compensation for subjective, non-monetary losses such as pain, suffering, inconvenience, emotional distress, loss of society and companionship, loss of consortium, and loss of enjoyment of life. Mr. Cohen's amendment, this is why it's so hard to have a serious discussion about this really important issue. Mr. Cohen's amendment suggests that we simply say, let's just agree that we won't apply these caps if a foreign object was left in the body of a person that was being operated on, or if the wrong person was operated on, or the wrong body part was operated on. You can't measure the loss in any one of those instances simply by how many days of work someone misses. There is pain and suffering, and we have a way to measure it. And that way the way that we do it through our civil justice system, you acknowledge is appropriate. That's why we keep this system in place. But you can't then refuse to acknowledge that there are certain things that are done. And I would suggest that the bill as a whole is problematic, but at least in this amendment, you can't simply argue that we throw out blame, that we acknowledge mistakes were made when someone has their wrong body part removed. It's just really difficult to understand that there's a serious commitment to addressing this issue of costs in medical care, which I think we absolutely, I join with my colleague, Professor Raskin, we absolutely ought to be having a discussion about. It's an important discussion. But to suggest on the one hand that we have a civil justice system, that we understand how it works because, again, as we've heard over and over, there are no caps on actual economic losses, but then to turn around and pretend that that justice system shouldn't work for people who have been so wronged by someone that they will have pain and suffering potentially for the rest of their lives, that's what makes it difficult for us to come together to have the kind of conversation we should have. I support Mr. Cohen's amendment, and I would respectfully suggest to my colleagues on the other side that you can continue to hold the position that you do on these issues, though we disagree, but at least acknowledge there are certain instances that are so egregious that our civil justice system, working the way it should be able to award damages to compensate for that, yes, non-economic, but very real damage that the injured party has sustained. I yield back.
Question occurs on the amendment offered by the gentleman from Tennessee. All those in favor respond by saying aye. Aye. Those opposed, no. No. Seeing the chair, the noes have it. The amendment is not agreed to. The gentleman requests a recorded vote, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from California, Mr. Issa.
Mr. Issa votes no.
Gentleman from Pennsylvania.
Mr. Marino votes no.
Has every member voted who wishes to vote? The clerk will report. Oh, the gentlewoman from Alabama.
Ms. Roby votes no.
The clerk will report.
Mr. Chairman, 12 members voted aye, 16 members voted no.
And the amendment is not agreed to. What purpose does the gentleman from Georgia seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1215 offered by Mr. Johnson of Georgia. Page 12, line 7, insert after or local government.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment would amend or would exempt claims against nursing homes and long-term care facilities from the sweeping litigation restrictions created by this legislation, H.R. 1215. Incidents of elder abuse occurring in institutional settings like nursing homes and long-term care facilities, as well as in private homes, continues to increase, especially as the number of residents in nursing homes grows. In 2014, the number of nursing home residents was approximately 1.4 million, and the number of residents in residential care communities was 835,200. Horrifyingly, more than 30% of all nursing homes have documented cases of resident abuse, either at the hands of staff or other residents. Abuse in nursing homes can range from physical, psychological, and sexual abuse to neglect and exploitation. However, only 20% of these cases are ever reported, let alone make it to trial. Abuse of seniors and disabled adults is one of the most undetected and underreported problems relating to health care. Last year, local Atlanta news broke the story of a terrible case of nursing home abuse in Gwinnett County, Georgia. Hidden cameras documented an employee forcibly dropping a woman from her wheelchair, strangling, kicking, and beating the victim over her head. As a man with an aging parent, I'm disgusted and abhorred that seniors face such abuse in these facilities, and we must ensure our seniors are protected. While state governments have created agencies meant to protect our vulnerable elder population and monitor nursing homes and other long-term care facilities, the threat of litigation has proven to be an effective deterrent to acute and systematic abuse of elders. Holding facilities accountable and responsible for the care of their residents and the actions of their employees is how we can keep our seniors safe. Georgia, in addition to each of its 12 area agencies on aging, have an elder abuse and prevention program through the State Department of Human Services, also has a robust state law in place so that abused victims can look to the courts for justice. Other states have taken it upon themselves to create nursing home bills of rights to protect their seniors. Such efforts by the states to protect the most vulnerable in our society would be completely undermined by this bill. My amendment looks to exempt cases involving nursing homes and long-term care facilities so that families can help their loved ones heal from such painful experiences. I ask my colleagues to support this amendment, but sadly, I must predict that each and every one of my colleagues on the other side of this aisle will be opposed to this very pro-consumer amendment. And you'll have to ask yourselves the question, why? And with that, I yield back.
For what purpose does the gentleman from Iowa seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. And this amendment should be defeated. The policy behind this bill benefits everyone, and it should apply to protect everyone, including seniors. Caps on non-economic damages are essential to the success of the Protecting Access to CARES Acts and its reforms. Here's what Cruz Reynoso, the Democratic Vice Chairman of the U.S. Commission on Civil Rights and former Justice of the California Supreme Court, has to say about the caps that have been in the law in California for over 25 years. Medical insurance has been going up. I think there's no question that what the legislature did and continues to do has had an influence on keeping those expenses down, and that's a very important public policy. Publicly funded medical centers are very supportive of the continued protection of MICRA because if their own insurance rates would go up, they would be less able to serve the poor. I personally have favored having as much access to the courts as possible, but at the same time, you have to be careful that it doesn't do so in a way that is destructive. For example, in a medical field, destructive of the ability of society to respond to the medical needs of the people, close quote. If this amendment's adopted, nursing homes and long-term care facilities will incur greater costs and they'll be able to provide fewer benefits. And listen to Donna Stidham, Director of Managed Care and Patient Services, AIDS Healthcare Foundation. Quote, an increase in the MICRA cap would increase our premiums phenomenally. It is a single clinic, in any single clinic setting, it could probably increase their premiums maybe $20,000 or $30,000. For multiple physicians, I'd hate to even guess, but it'd be in the hundreds of thousands of dollars, which would take away from direct patient care. And so it would directly take away from care from patients. You'd see us perhaps not being able to admit all types of patients. Right now, we can take any kind of patient, whether they have the ability to pay or whether they don't. Close quote. Two top economists have conducted two extensive studies using national data on Medicare populations and concluded that patients from states that adopted direct medical care litigation reforms, such as limits on damage awards, incur significantly lower hospital costs while suffering no increase in adverse health care outcomes associated with the illness for which they were treated. California's 4-decade track record shows that a $250,000 cap on non-economic damages lowers health care costs and makes health care more accessible to everyone, including seniors. And I would point out that the caps that exist in the states that have passed that legislation are not preempted by this bill. The respect of states' rights is as intact as it has ever been in the proposal that we have before us today. And I want to commend everyone for working in that direction. And I urge the defeat of this amendment, and I yield back the balance of my time.
Mr. Chairman,
For the purpose, the gentleman from Rhode Island seek recognition.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Chairman, sometimes you think you're in an Alice in Wonderland story. The gentleman from Iowa just said the reason he opposes this amendment will undermine the benefits of the bill, which should apply to everybody. Let's be clear about this. The policy behind this bill will benefit corporate special interests and hurt the American people, particularly those that are hurt by the misconduct or erroneous actions of others. The very purpose of our civil justice system is to provide an organized way to compensate people who are harmed by the conduct of others and to discourage other potential wrongdoers from doing the same thing. And that is the very principle for the creation of our civil justice system. This bill eviscerates that. And I associate myself with the comments of the gentleman from Maryland and the gentlelady from Washington. This does it with a bulldozer. It virtually eliminates the ability for people who have been hurt to receive their full compensation for the wrongdoing that was done to them. But at least this amendment carves out some protection for a particularly vulnerable population, our seniors. And sometimes when you hear the argument that this bill is so good and these amendments are going to prevent all of the benefits from being experienced by everyone, you just wonder where you are. And so I urge my colleagues to make a horrible bill a tiny bit better by supporting this amendment, and I yield back.
What purpose does the gentleman from Texas seek recognition?
Abstract the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. And I appreciate friends across the aisle, the comments. In Texas, we lost hospitals, we lost doctors down in our Rio Grande Valley. We had so many people that were not able to get the health care they needed because of, malpractice insurance rates went through the roof. And doctors could not afford, in some places in Texas, continue to practice there. They just could not afford the malpractice insurance. So Texas did malpractice tort reform, and doctors came back, hospitals came back, people were able to get the insurance they needed that would allow them to continue to practice there as some had before. I don't have a better friend in Congress than the gentleman from Iowa, for whom I have the utmost respect. But this is a bill proposed similarly by others. Would applaud the efforts of my friend, Mr. King, for making it a bit more, providing more of a nexus than had been provided in the past. But I've seen the way that doctors and hospitals have come back to areas of Texas where we had lost them. In prior Congresses, when discussing this issue of a federal bill that would usurp the state law of torts in this area, I've commented before in response to someone saying, look, Illinois has tremendous malpractice insurance cost, and this will help them. And my comment in prior Congress was, if Illinois wants to run off all their doctors with ridiculously high malpractice insurance or the threat of just completely debilitating malpractice claims and lawsuits, then that's Illinois' business. The federal government should not intercede and take away the state's rights. Like I said, there's much more nexus that has been written into this bill, but also my concern, having seen doctors and hospitals come back into areas of Texas where they left after our tort reform, by passing a bill like this, we would send a message that when any one of my friends across the aisle became speaker and you wish to come into Texas and completely eviscerate the previous tort reform or malpractice reform that we had done in Texas or that the state legislature had, then Republicans would not be in a position to object and say, you can't go take away states' rights. And I intend to be able to say that if this day ever comes. So I will be voting against the bill ultimately, and I yield back.
Question occurs on the amendment offered by the gentleman from Georgia. All those in favor respond by saying aye. Aye. Those opposed, no. Any of the chair, the noes have it. The amendment is not agreed to. Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Arizona.
Mr. Franks votes no.
The gentlewoman from Alabama.
Ms. Roby votes no. Not recorded. Mr. Cohen votes aye.
The clerk will report.
Mr. Chairman, 13 members voted aye, 15 members voted no.
And the amendment is not agreed to. The chair recognizes himself for the purpose of offering an amendment, and the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1215 offered by Mr. Goodlatte. Page 6, strike line 20 and all that follows through line 21.
Without objection, the amendment is considered as read. I'll recognize myself for 5 minutes to explain the amendment. I'm offering this amendment to strike the collateral source portion of the bill simply because I think that insofar as the bill might deny a person's ability to take advantage of the benefits of his or her own health insurance, that effect should be mitigated. To that end, I'm offering the amendment to strike Section 5 of the bill, the section on collateral source benefits. Two public policy reasons. One, we should encourage people to have health insurance, not discourage it. And secondly, we do not permit, this provision in the bill, if it were allowed to remain, would permit defense attorneys to tell the jury that the plaintiff has health insurance. We do not permit, under this bill or other law that I'm familiar with, the plaintiff's attorneys to tell the jury that the defendant has medical liability insurance. So to me, I think this is an issue of fairness. For purpose of the gentleman from Michigan seek recognition.
I want to congratulate you. You make a bad bill a little bit better.
I thank the gentleman. The question occurs on the amendment. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the ayes have it, and the amendment is agreed to. For purpose of the gentleman from Georgia seek recognition.
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1215 offered by Mr. Johnson of Georgia. Page 17, line 15, insert after federal law the following. No provision.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. At my last amendment, I reported to everyone that I expected that all of the members on the other side of the aisle would vote no, since that one was a consumer-friendly amendment. Well, this amendment that I'm about to introduce is a consumer-friendly amendment, but it's also a states' rights amendment. And so therefore, I'm pleased to report that I expect that one member on the other side will support this amendment, and I'm optimistic that he will come back and vote and go against the grain and vote for this very reasonable amendment. My amendment looks to limit this egregious attack on states' rights by preventing the federal government from interfering in a state's ability to amend its constitution or pass laws so that its citizens are protected from dangerous medical products and medical negligence. 440,000 people die every year from preventable medical errors, and state legislatures have taken it upon themselves to protect patients and hold or allow the holding of wrongdoers accountable for their negligence. However, H.R. 1215 selectively preempts these carefully constructed state laws at the expense of vulnerable patients. Instead of preempting state law with a uniform federal standard, the bill only overrides those laws which are more protective of injured patients and families so that defendants such as healthcare conglomerates, health insurance companies, and hedge fund-owned nursing homes can gain an unfair advantage in courts. H.R. 1215 looks to impose policies and procedures in many places where the state courts have found such efforts unconstitutional, according to the state constitutions. In 2010, the Georgia Supreme Court found limits on non-economic damages in medical negligence cases and other cases to be unconstitutional. Yet this bill imposes a $250,000 non-economic damages cap on the state of Georgia. My amendment would protect states' rights by prohibiting the implementation of provisions in states where the state constitution explicitly addresses the policy. So states that have constitutional prohibitions on damages caps like Pennsylvania, Kentucky, and New York would not be forced to adopt H.R. 1215's non-economic damages cap. Unfortunately, such sweeping preemption of state law by H.R. 1215 comes at the expense of individuals hurt by medical malpractice or dangerous products, as well as families suffering under the weight of crippling medical bills and lost wages caused by medical negligence. H.R. 1215 is an unnecessary attack on one of the fundamental tenets of our civil justice system. If a patient is injured, that claim should be brought under state law in a state court following that state's rules of civil procedure with damages limited only by that state's laws. Considering the administration's recent decisions to defer to state law on the issue of transgender students, I'm surprised to see this committee putting forth legislation that utterly undermines the ability of states to protect their own people from medical negligence. My amendment would ensure that states which have carefully protected the rights of their citizens through their state constitutions and statutes are allowed to keep those laws on the books. And with that, I ask my colleagues to support this amendment, and I yield back.
The gentleman returns his time. The chair will now recognize himself to strike the last word. And this amendment should be defeated. First, this bill applies only to federal issues. And we've addressed that nexus, I think, carefully in previous components of the debate. The Protecting Access to Care Act contains an explicit federal nexus. The bill's reforms only apply to lawsuits concerning the provision of health care goods or services for which coverage was provided in whole or in part via a federal program, a federal subsidy, or a tax benefit. That's the language that includes the federal nexus that we've discussed. Wherever federal policy affects the distribution of health care, there is a clear federal interest in reducing the cost of such federal policies. The bill also includes provisions in each section that allows states to opt out of each provision, provided that they have their own limits on non-economic damages. Those damages, they have to be in place and either higher or lower than that set out in the bill. And states can react to this legislation and amend their non-economic damages if they disagree with the federal guidelines that we have in this underlying bill, and other limits that provide the same or greater protections as those provided for in the bill. Further, many state Supreme Courts have judicially nullified reasonable litigation management provisions enacted by state legislatures. And so if the voice of the people in the state legislature aren't respected by a state court, but there's a federal nexus to this litigation that takes place, then these caps apply. But if the states disagree with the caps that we have in the bill, they can amend that through their own statute. So consequently, in such states, passage of federal legislation by Congress through the people's duly elected representatives may be the only means of addressing the state's medical professional liability regime and restoring patients' access to health care, also as previously discussed. So I urge all my colleagues to join me in opposition to the amendment.
Will the gentleman yield?
And I yield back the balance of my time.
Mr. Chairman,
For what purpose the gentleman from Michigan seek the floor?
I seek the floor to support the Johnson amendment.
Gentleman's recognized for 5 minutes.
And I yield to the gentleman briefly.
Thank you, Mr. Chairman. Section 3E of the bill provides that the bill shall not be construed to preempt state law that specifies a cap on economic or non-economic damages that may be awarded in a healthcare lawsuit. But notably, this provision effectively means that the bill will preempt state law that imposes no such caps on damages. And so I think that my amendment is a good one, and I'd ask my colleagues for their support. And with that, I yield back.
Yes, I'd like my colleagues on the committee to consider that many of the members of the majority consider themselves to be ardent supporters of state sovereignty, yet this legislation would preempt many aspects of state law in many states. I support this bill, this amendment, because it would prevent the preemption of any state constitutional provision that might be otherwise preempted by this bill. I believe that state courts and legislatures have the primary authority to shape tort law, as they have historically, and if you do, then you should support this amendment with me. I thank the chair, and I yield back the balance of my time.
The gentleman yields back the balance of his
Does
time.
someone want me to yield? Yes,
the ranking member.
gentleman from Maryland, I'm pleased to yield to.
Thank you very much, Mr. Conyers. I'm delighted to rise in favor of the Johnson amendment. I wish I had introduced it myself. It says simply, no provision of this act shall be construed to preempt any provision of a state constitution. And those of us who have served in state legislatures across the country know that no power is more jealously guarded by our states than the power to regulate what happens in our own courts with respect to tort law and personal injury, people who are victimized by toxic torts or lead poisoning purveyors, or people who practice law or medicine or other trades with malpractice. This goes right to the heart of state sovereignty. And for those of us, left, right, center, liberal, Democrat, Republican, who believe in state power and the power of the states to govern their own affairs, will definitely support the Johnson Amendment. And those of us who believe in the Constitution of the United States and what the founders were up to should also look hard at this amendment, because the founders of the Constitution were concerned very much with the way that the king was imposing prosecutors and judges and courts on the people of the colonies and trying to rule over us through the courts. And so the power to govern ourselves in our states is an essential constitutional power. I was delighted to hear Mr. Gomert from Texas, who I know is a longtime champion of states' rights and state sovereignty, say that he could not support the bill. but I would hope that everybody, even those who are supporting the bill, those who are opposed to the bill, can agree to this amendment that we should not be trampling the provisions of our own state constitutions that our people have adopted in our states. And so with that, again, I want to thank the gentleman from Georgia for having the insight to cut through all of the nonsense about this bill and get right to the heart of the matter. We are usurping the prerogatives and the powers of the states. At the very least, we should not throw the state constitutions in the dustbin with everything else. With that, I would yield back to the ranking member.
I yield back.
Mr. Gentleman from Michigan yields back the balance of his time. The question is now on the amendment. All in favor of the amendment will say aye.
Aye.
All opposed will say no. No. It appears the noes have it. The noes do have it. The gentleman has requested a quarter vote. The clerk will call the roll.
Mr. Goodlatte? Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King?
No.
Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes yes. Mr. Biggs? Mr. Biggs votes yes. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Is there anyone who wishes to cast or change their vote? Gentleman from Wisconsin?
Mr. Sensenbrenner votes aye.
Gentlelady from Alabama?
Ms. Roby votes no.
Gentleman from Texas?
Mr. Poe votes no.
Chairman Goodlatte?
Mr. Goodlatte votes no.
Gentleman from Utah?
Mr. Chaffetz votes no.
Gentleman from Arizona?
Mr. Franks votes aye.
Gentleman from Florida?
Mr. Deutsch votes aye.
Anyone who wishes to cast or change their vote?
Change my vote to
Gentleman from Louisiana?
no.
Mr. Johnson votes no.
And the gentleman from Arizona? Mr. Biggs from Arizona?
Mr. Biggs votes no.
Votes no. Gentleman from Arizona?
Mr. Franks votes no.
Mr. Chairman, may I ask how I'm recorded? Mr. Chairman?
Not recorded. Mr. Gutierrez votes aye.
Gentleman from Wisconsin?
Mr. Sensenbrenner votes no.
The gentleman from Ohio.
Mr. Jordan votes no.
Johnson switched.
It's just two.
The council. Who is it?
15, 16. Labrador and
Radcliffe.
what's your son? It's right now. It's not
Radcliffe
Roby.
is a yes?
No, it's not Roby. It's
Mr. Chairman. Mr. Chairman, might I be recognized?
it's just Labrador.
Not during a vote.
Mr. Chairman, how am I recorded?
Young lady from Texas.
Aye.
How am I recorded?
Aye.
No. That's Mr. Buck. I would to ask if he's recorded.
He's no.
He's no. He's no.
All these guys changed.
16 to 15, yes. So we need one more member to change your vote. Labrador? He won't switch? We need a member to get here or something. Lamar Smith.
Mr. Chairman, point of parliamentary inquiry. Mr. Chairman, point of parliamentary inquiry. Well, the parliamentary inquiry is how long do we have to wait for you to continue to change people's minds or call the vote?
There will be no demonstrations in this room. The gentleman from Virginia. The gentleman from Wisconsin. Gentleman from Wisconsin changes his vote to aye. Anyone additionally wish to cast or change their vote?
Mr. Chairman, how am I recorded?
You can recognize who's speaking. The gentleman
Mr.
from
Chairman,
Wisconsin.
how am I
From
recorded?
Maryland, how are you recorded?
Aye.
Thank you.
As an aye.
Mr. Chairman, how am I recorded? There have been all these changes, and I just want to make sure you've got my vote correct.
Aye.
Aye, thank you.
Anyone in addition wish to cast or change their vote? Seeing none, the clerk shall report. The clerk shall report.
How am I recorded?
The clerk shall report.
How am I recorded?
The clerk shall report.
You can ask for the panel if I'm asking
The gentlelady shall observe regular order, and the clerk shall report.
Mr. Chairman, 16 members voted aye, 15 members voted no.
The amendment is agreed to and adopted. And the chair would now recognize the
Mr. Chairman?
Will the clerk report the vote again?
Mr. Chairman, regular
Report the vote
order.
again. Will the clerk report the vote again?
This has to be a breach of regular order, Mr. Chairman.
We want an accurate reading from the
Parliamentary
tally,
inquiry
and
as
the
to-
record will show
The record vote has been
recorded vote.
reported.
Mr. Goodlatte?
No, just report the tally.
If it's open,
Mr. Chairman, how's the gentleman from New York recorded?
As an aye.
Mr. Jeffries?
Mr.
No. Has to be someone on the prevailing side.
Mr. Chairman, it's Faye
Parliamentary
Dunaway
inquiry,
here.
once the vote has been announced, isn't the vote closed?
I have an amendment at the desk.
The gentlelady from Texas has an amendment at the desk, and the previous amendment has been adopted. The gentlelady from Texas is recognized for her amendment.
Mr. Chairman, a point of parliamentary inquiry before we take the next amendment.
Recognize the gentleman from,
Mr. Chairman, I would ask whether the rules authorize you to make available the 15 vacant seats in the front row. We're nearing the end of this amendment process. There are people waiting outside, and I would ask whether you can do that. If you can't do it alone, I'd make a motion to authorize those 15 seats to be available to members of the public who are waiting.
Second.
I'd ask the gentleman to restate his request.
To make the 15 seats that are vacant and available in the front row to members of the public who have been waiting outside the door so they can witness their democracy at work.
Second.
Gentlemen, it's not a parliamentary inquiry, and by the way, we need to keep that side open. The gentlelady from Texas.
Point of order. Point of order, Mr. Chairman.
Mr.
There's a
Chairman,
motion
parliamentary
made and
inquiry.
second.
Mr. Chairman, parliamentary inquiry.
Gentleman from New York.
For whom are those seats being reserved?
We need staff to be able to move across the aisle on that side. We could open up a few seats on the left side.
Even if
Yeah,
all
we
the
can- we
seats
can
are opened
open-
up, staff could move.
We can open up a few seats, but the front needs
staff.
to be open for staff to be able to move. And so I appreciate the gentleman from New York. We're going to move on and recognize the gentlelady.
Mr. Chairman, I believe there's a motion that has been made and
that
seconded by
on
the
the fly.
gentleman from California. I'd ask for a vote.
We'll accommodate what we can off the record. And gentlelady from Texas
Mr. Chairman, a
shall proceed.
motion
The
has
gentlelady
been
from
made
Texas shall
and
proceed.
seconded, and I'd ask for a vote. Point of order, Mr. Chairman.
Chairman, I call for the regular order.
Point of order,
I
Mr.
requested the
Chairman.
gentlelady from Texas is recognized for her amendment, for 5 minutes for her amendment.
Let me offer my agreement with the Cicilline motion that was not taken up, and I do believe that we should open these seats so that the people of this nation have the opportunity to be able to watch truth and democracy be in play.
There'll be no demonstrations in this room, or I will ask the Sergeant-at-Arms to clear the room. The gentlelady shall proceed.
Continuing with my amendment, I have an amendment at the desk which has been distributed. I am concerned about this bill as it puts the patient safety at higher risk by significantly undermining the accountability of those who provide patients with medical care. Let me acknowledge the amendment of Mr. Johnson that would argue for the passage of my amendment for this legislation would impose various restrictions on medical malpractice lawsuits, causing these restrictions to apply regardless of how much merit a case may have, the negligence at issue, or the severity of the issue. Nothing is more devastating to a family than the loved one whose life has been lost or who has been severely and permanently injured. H.R. 1215 would have preempted state law in all 50 states. Now, with the passed amendment, we should look to make sure that the specific prohibitions do not stand. The Jackson-Lee Amendment would exempt the claims of victims who allege an irreversible injury from the bill's purview. Those are victims who suffer the most devastating loss of wages, loss of ability to provide for themselves. The amendment protects victims filing medical malpractice, tort-based legal claims for damages arising out of an irreversible injury caused by a healthcare provider. Victims injured by the negligent conduct of others who have lost limbs, suffered traumatic brain injury, or may be unable to see following medical procedures should not be subject to additional burden of a possible limited recovery currently available under a number of legislative initiatives. Empirical research has shown that caps on damages, however, as those envisioned by H.R. 1215, diminish access to the courts for the most vulnerable, such as low-wage earners like the elderly, children, and women. If economic damages are minor and non-economic damages are capped, victims are less likely to be able to obtain counsel to represent them in seeking redress. Those affected by caps on damages are the patients who have been most severely injured by the negligence of others. And so the idea of this legislation is to, in fact, undermine the severe injury to individuals who seek recovery. Let me give an example as I close. Pam Bushell, East Grand Rapids woman who lost her arms and legs to amputation while battling septic shock, has filed a medical malpractice lawsuit against her doctor. Women undergoing elective hysterectomy do not expect to wind up with their arms and legs amputated. Before surgery, Pam was a healthy, vibrant mother. She led a fulfilling life as a public school social worker, helping autistic and special needs children. Now she is an amputee. What happened was the couple were told that their problems were not life-threatening after they spoke about an impaired urinary function that was reported to her doctor. What should have been an easily treatable urinary tract infection instead progressed to urosepsis, a lethal condition where the infection enters and circulates the bloodstream. How many families have experienced not being listened to and a severe injury occurs? I ask my colleagues to support the Jackson-Lee Amendment that deals with the impact of this legislation on individuals who experience severe irreversible injury, and I ask for the support of those patients who cannot take care of themselves any longer. That I yield back.
The gentlelady yields back. The chair would now recognize himself for 5 minutes in opposition to the amendment. This amendment should be defeated. This amendment would gut the bill in that most injuries are irreversible. The point of the bill, however, is to reduce health care costs and to make doctors more accessible to everyone, so whatever injuries people have can be treated, and be treated in a cost-effective manner that maximizes health care resources for everyone. Under this bill, any irreversible injury could receive damages in the range of tens of millions of dollars, as occurred in California, for example, where these provisions have been in place for over 40 years. I urge my colleagues to oppose this gutting amendment, and I point out that a string of these amendments, if added up, do completely nullify the bill, and so they appear to be targeted to the most sympathetic components that one can devise. But if California thinks enough of their legislation that in spite of the majorities that they have in their state legislature, they haven't amended this legislation, then I suggest it's a pretty good idea for us to follow, and probably one that stays well within the bounds of reason. So I urge opposition to the Jackson-Lee amendment, and I yield back the balance of my time. And the question is now on the amendment, on the Jackson-Lee amendment. All in favor signify by saying aye.
Aye.
All those opposed, say no. No. Then a recorded vote has been called. The clerk shall call the roll.
Mr. Goodlatte? Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King?
No.
Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. Conyers? Aye. Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee?
Aye.
Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye.
Right. That ain't good.
Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Gentleman from Idaho.
Mr. Labrador votes no.
Gentleman from Georgia.
Mr. Johnson votes aye.
Has every member voted who wishes to vote?
Mr. Johnson votes no.
Gentleman from Florida.
Mr. Deutsch votes aye.
Obviously, what's going on with that? You didn't ask the question?
Clerk will report.
Mr. Chairman, 14 members voted aye, 19 members voted no.
And the amendment is not agreed to. Are there any further amendments?
Chairman,
First, the gentleman from Wisconsin, Secret.
Mr. Chairman, I move to reconsider the approval of the Johnson Amendment. I voted on the prevailing side.
Mr. Chairman, I have an amendment at the desk.
We're in the midst of reconsideration of the Johnson Amendment. The question is on the reconsideration. All those in favor of...
Mr. Chairman, I move to table.
That's not a proper motion.
Mr. Chairman, I make a parliamentary inquiry.
Gentleman will state his parliamentary inquiry.
Is Mr. Sensenbrenner's motion debatable?
The motion is not debatable.
He said it's not in order already.
All right. Motion's been made to table the motion reconsider.
Actually, Mr. Chair, I withdraw my motion.
Motion is withdrawn. The question,
Mr. Chairman.
Mr. Chairman, I move to strike the last word.
It is debatable. Motion to reconsider is debatable.
the gentleman is recognized for 5 minutes.
Thank you, and I would yield to my colleague from Texas, Ms. Jackson-Lee.
I thank the gentleman for his yielding, and I rise to oppose the motion for reconsideration on the basis that we had a duly debated motion of Mr. Johnson dealing with states' rights, which if I look to the factual part of it, all of my colleagues on the other side of the aisle are strong proponents of states' rights. There is no technical flaw to Mr. Johnson's motion, nor is there a legal flaw to Mr. Johnson's motion. And under the 10th Amendment of the Constitution, it is perfectly legitimate to leave certain items to the states. And that is Mr. Johnson's premise, is that states' rights prevail to the extent that states are engaged in the issue of a legal structure that deals with medical malpractice. The basis of the reconsideration seems to be, at best, a whim, and the fact that members have now come to overturn, which has been a legitimate vote and debate on the merits of Mr. Johnson's amendment, which is that states' rights should prevail to give better rights or more rights to victims of medical malpractice. And when the state does not cap the injuries, or in some instance economic caps, then we should not deny that benefit to those who live within the boundaries of that state. I would raise the question and oppose the reconsideration of the vote and count that occurred on Mr. Johnson's amendment. I yield back.
Reclaiming my time. Thank you, Ms. Johnson. Mr. Chair, I yield to the gentleman from Georgia, Mr. Johnson.
Thank you. Mr. Chairman, I would inquire as to why the other side seeks to reconsider its duly recorded vote on an issue that we all know, states' rights, being so important and fundamental to the politics of the other side. I would just like to know why, and I would yield to the gentleman to explain.
I don't think the gentleman chooses to explain.
Well, perhaps in a few moments of silence to allow him to explain might be in order. Sometimes silence can be deafening. Mr. Chairman, the silence was so painful that I must call off this inquiry. I must have mercy and compassion. And with that, I would like to yield back to my colleague, Mr. Swalwell.
Reclaiming my time, thank you, Mr. Johnson, and I think it's the position of our side and hopefully many on their side that you go with your gut, which was to stand with state rights, which is also, I think, a foundational principle that has guided so many on their side for so long. Yield back.
Mr. Chairman.
Oh, Mr. Chair.
What purpose the gentleman from New York seek recognition?
Strike last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, unlike some others, I am not a fanatical devotee of states' rights. Like most people, I am in favor of states' rights when it gives certain results and against states' rights when it tramples individual liberty or gives bad results in other ways. But let me just say, in answer to the questions that were raised, what happened here was obvious. The majority did not have his votes in line and lost on the amendment. The vote was kept open, as we all saw, while votes were rounded up, or the attempt was made to round up enough votes, and it was unsuccessful. A number of people who had voted for the amendment on the Republican side, as a matter of their consciences, were induced to change their votes, but that didn't avail. Mr. Sensenbrenner then changed his vote from yes to no so that he could be in the prevailing side in order to make a motion to reconsider when enough of the Republicans were back. If we take as a principle of organization that the majority should never be so careless as to lose a vote, then there's nothing wrong with this. If we take as a principle of organization that majorities should prevail when the votes are cast, then this is unfortunate and not in the best interest of proper procedure. But that's what happened. I think it is regrettable. The amendment was adopted. It should be permitted to stay there. It's a very bad bill. It makes it a slightly less bad bill. I yield back.
Mr.
Chairman. The question is on the motion to reconsider.
Mr. Chairman. Mr. Chairman.
What purpose does the gentleman from California seek recognition?
I move the previous question on the motion to reconsider.
The previous
Mr.
question,
Chairman, I move to strike the last word.
the motion for the previous question is not debatable. The question is on the previous ordering the previous question. All those in favor respond by saying aye.
Aye.
Those opposed, no. Seeing the chair, the ayes have it.
Record vote, please.
Record vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes yes. Mr. Collins? Mr. DeSantis? Mr. DeSantis votes yes. Mr. Buck? Mr. Buck votes yes. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers? No. Mr. Conyers votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? No. Mr. Cohen votes no. Mr. Johnson of Georgia? No. Mr. Johnson votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? No. Mr. Jeffries votes no. Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? No. Ms. Jayapal votes no. Mr. Schneider?
No.
Mr. Schneider votes no.
Mr. Chairman, Mr. Chairman, how am I recorded?
Not recorded.
No.
Ms. Jackson Lee votes no.
Mr. Chairman, how am I recorded? That was me, Bass.
Not recorded.
No.
Mr. Chairman, parliamentary inquiry.
Gentleman will state his inquiry.
Is the passage of this resolution, does that mean debate ends?
Just on the motion to reconsider.
So I want to be clear for people in the audience, we can no longer debate. That's the purpose of the motion.
Just the motion to reconsider.
Is that correct?
Just the motion to reconsider, not
Yeah.
subsequent
It
amendment.
ends debate on the motion to reconsider that
correct.
we are in the middle of.
That's correct.
Okay, thank you.
Gentleman from Florida.
Not recorded. Mr. Deutsch votes no.
Has every member voted who wishes to vote? Clerk will report.
Miss,
Clerk will
Not-
suspend.
not recorded. Mr. Marino votes yes.
Clerk will report.
Mr. Chairman, 19 members voted aye, 15 members voted no.
And the motion for the previous question is approved. The question is on the motion to reconsider, and the clerk will call the roll. Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes yes. Mr. Collins? Mr. DeSantis? Mr. DeSantis votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? No. Mr. Cohen votes no. Mr. Johnson of Georgia? No. Mr. Johnson votes no. Mr. Deutsch? No. Mr. Deutsch votes no. Mr. Gutierrez? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no.
The gentleman from Arizona? The gentleman from Idaho?
Mr. Labrador votes yes.
Has every member voted who wishes to vote? Clerk will report.
Mr. Jordan votes yes.
The gentlewoman from Texas?
Not recorded. Ms. Jackson Lee votes no.
The clerk will report.
Mr. Chairman, 19 members voted aye, 15 members voted no.
And the motion to reconsider is agreed to. The question occurs on the Johnson Amendment. The clerk will call the roll.
Mr. Chair, I move to strike the last word.
It's not, the previous question has been called. Clerk will call the roll.
Mr. Goodlatte?
The previous question was not called, I'm told. Not on this. Yes, the previous question was called on the motion to reconsider. Now the motion to reconsider, now consideration, now the question before us is on the amendment. The debate is on the underlying amendment now. The previous vote having been reconsidered.
Gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. This has been unprecedented in my 10 years here in Congress. I've never seen anything like this before, where we had argument on a motion, the motion carried after a tortured process of trying to get people to change their votes. And despite the effort that was made towards that, there were some who stuck by their principles. And there's one who I'd like to recognize right now, my good friend, Judge Poe, out of Houston, Texas, who has done the right thing. We don't agree on a whole lot, but we can agree that this man is consistent and has some character. And he has disappeared into the back room. And when folks disappear into that back room, things have happened. It's been maybe some arm twisting going on figuratively or perhaps even physically. I don't know. But some changes occur when people go to that back room. But I trust Judge Poe is coming out and going to remain consistent. Now, question is, who is twisting arms in that back room back there?
Mr. Chairman, point of inquiry, is the gentleman implying physical force or duress?
No.
It does appear as though the gentleman is disparaging the tactics of the chairman.
No.
Which I certainly think do not include any of that.
Mr. Chairman, my time is continuing while we.
Well, if the gentleman would suspend from disparaging the conduct of anyone, then I'd have no problem.
Well, I was speaking figuratively, and I think I said that. And I would like for my 40 seconds to be added back to my time, Mr. Chairman. Mr. Chairman?
What purpose? The gentleman controls the time.
Well, we took 40 seconds of my time to go through what we just went through. I don't think that should be attributed to me.
Keep on making your point.
Well, my point is bad things are happening back there in that back room. And we're all wondering who it is back there that is, figuratively speaking, twisting arms. I don't know whether or not it's just figurative or whether or not it's physical.
Mr. Chairman, I ask that the gentleman's words be taken down. I think he's crossed the line again and again, figuratively or literally. Gentlemen, I'll suspend.
Does the gentleman wish to respond to the motion to have his words taken down?
Yeah, we're getting real close to First Amendment violations here, Mr. Chairman. We're getting to the point, we're having an Elizabeth Warren moment in the House of Representatives.
The gentleman will suspend. The gentleman must abide by the rules of the House and the rules of decorum of the House. So the gentleman's choice is to withdraw his words or have them taken down.
Well, my words were not impugning the motives or integrity of any member on the other side. And, but I guess the deck is stacked against me in terms of the ruling on whether or not my words were so impactful. So with that, I will withdraw my words. But I will again point to that back room and wonder what's going on back there. And I leave it up to everyone's conscience to decide whether or not the people are benefiting. I know that with that amendment that I made, which is passed.
Would the gentleman yield?
In just a second. I know that that amendment protects consumers, is pro-consumer, is pro-patient, because we know that sometimes a plumber makes a mistake, and when a plumber makes a mistake, we want to go ahead and sue him and get some relief. Same thing with an electrician or with somebody who is purveying unwholesome food. We want to be able to hold them accountable in the civil arena. And that's what this amendment allows us to do in the state courts. And so this is a good amendment. I'd ask that my colleagues not rescind their support for it, and with that, I'll yield back.
Mr. Chairman.
Mr. Chairman.
Mr. Chairman.
And I'd be happy to yield my additional 40 seconds that I should have been granted to the gentleman.
The chair will Without objection, the chair will give the gentleman an additional 1 minute, and he can yield it to whoever he chooses.
He gave you a minute.
All right, with that minute, Mr. Chairman, and I thank you, I would yield to the gentleman from California. Or whoever it was that asked for.
Yeah. Well, I appreciate that. I move the previous question.
I reclaim my time.
Chairman, I strike the last word.
Would the gentleman yield?
I'd like to strike the last word. I'd like to strike the last word.
Time is controlled by the gentleman from Georgia. After his time is concluded in 1 minute, we can then move to the next motion.
Mr. Chairman, I yield the balance of my time.
To whom?
I yield back.
All right.
Thank you, Mr. Chairman. I seek recognition.
Mr. Chairman.
Question occurs on the Johnson Amendment.
Mr. Chairman.
All those in,
Are we not allowed to comment on the Johnson Amendment?
I move the previous question.
I move to strike the
question
last
has
word.
been moved. We can either go to a vote or we can go to 2 votes.
He did it on the pretense of
In
having
that
time
case, then,
yielded to him,
Mr. Chairman,
masquerading that he was engaged in debate, and
I
I
would-
think we should continue with debate.
I would withdraw my yielding of my time.
correct.
The gentleman is
And
not
offer-
allowed to withdraw his yielding of time. The gentleman from California has moved the previous question.
Yeah.
The question is on moving the previous question.
Ask
The
for
clerk
record
will
vote.
call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner?
Is that,
Mr. Smith?
can I do it?
Mr. Shabbat? Mr. Shabbat votes aye. Mr. Isa? Mr. Isa votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert?
Can hear it.
Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? No. Mr. Johnson votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Jeffries? No. Mr. Jeffries votes no. Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no.
Wipe that smile off.
Gentleman from Wisconsin.
Mr. Sensenbrenner votes no.
Parliamentary inquiry, Mr. Chairman.
The gentleman from Texas.
Mr. Poe votes no.
It's going to fail. Mr. Farenthold.
Mr. Farenthold votes yes.
Mr. Chair, if you can.
Gentleman from Tennessee.
I don't think I was recording.
No.
That's right.
Gentleman from Illinois. Gentleman from Illinois.
Not recorded. Mr. Gutierrez votes no.
Gentleman from Idaho.
Mr. Labrador votes yes.
Clerk will report.
Mr. Chairman, parliamentary inquiry.
The clerk will report. Parliamentary inquiry is not in order during the vote.
Mr. Chairman, 16 members voted no, 18 members voted aye.
Previous question is ordered. The question is on the Johnson Amendment. Clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen?
Aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia? Aye. Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Yes. Mr. Gutierrez votes yes. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Arizona.
Mr. Franks votes no.
I'm sorry, may I ask how I'm recorded? Schneider.
Mr. Raskin wants to know how he's recorded.
No, Schneider.
Oh, Mr. Swalwell.
No, Schneider.
Oh, Schneider, I'm sorry.
You're on the end.
Yes.
Thank you.
The clerk will report.
Mr. Chair, how am I recorded? Swalwell.
Yes.
The clerk will report.
Mr. Chairman, how am I recorded?
Mr. Chairman, how am I recorded?
You're recorded as an aye for your amendment.
Mr. Chairman, how am I recorded?
The clerk will report.
Mr. Chairman?
Mr. Chairman, how am I recorded?
You're recorded as an aye.
Mr. Chairman, how am I recorded?
As an aye.
Mr.
I
Chairman,
believe
how
there's
am I
a-
recorded?
How is Mr. Deutsch recorded?
Clerk will
Mr.
report.
Deutsch votes aye.
Clerk will report.
Mr. Chairman, 17 members voted aye, 17 members voted no.
And the amendment is not agreed to. Are there further amendments?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1215 offered by Mr. Raskin. Page 4, strike line 10, and all that follows through line 21.
Without objection, the amendment is considered as read, and the gentleman is recognized on his amendment.
Thank you, Mr. Chairman. This amendment seeks to protect victims of sexual assault. My amendment would exclude cases from H.R. 1215 in which the plaintiff sues for malpractice after being treated for injuries resulting from sexual assault or rape. Such situations wouldn't be covered by the exclusion in the bill for claims based on criminal liability because the crime is of sexual assault or rape, and the claim is based on subsequent healthcare malpractice.
Mr. Chairman, H.R. 1215 takes away the discretion of judges and juries to impose damages of more than $250,000 for non-economic damages, no matter the facts or of the individual situation. As someone who was a prosecutor for 7 years, I trust judges and my fellow Americans who serve as jurors to award an appropriate level of damages. And many people here today, Mr. Chairman, I think are wondering, will the majority of the members of this committee continue to vote against plaintiffs and their rights to access the courts? And I hope that is not the case with respect to sexual assault victims. I would also add H.R. 1215 reaches into state courts and imposes the same caps on damages in their cases as well. My amendment illustrates how wrong-headed the approach of trying to have caps is. According to the Bureau of Justice Statistics National Crime Victimization Survey, there were over 200,000 victims of rape or sexual assault in 2015. The vast majority of these survivors are women. Beyond the physical injuries which result from rape and sexual assault, there is, of course, the emotional trauma. Women who are victimized in this way can and must show tremendous courage as they deal with their injuries and rebuild their lives. But what happens when, on top of being victimized by their rapist or sexual assailant, they're hurt by the negligence of their healthcare provider as they seek treatment for their injuries? Maybe it's a therapist who acts negligently, or a doctor who fails to show due care in treating their wounds, or a violation of their privacy. If these heroic women seek to assert their rights in court and win under H.R. 1215, they'd be harmed all over again because their pain and suffering damages would be capped at $250,000. It is beyond me that anyone on this committee could sit here and tell any woman across our country that they know that in every situation, no matter how horrible the rape or sexual assault, if you are a victim of negligence in seeking treatment, your damage award should be capped. To me, that is ensuring that these women would be victimized all over again. I urge my colleagues, protect victims of sexual assault and rape. If this terrible bill were to become law, the least we can do is not re-victimize those who have suffered rape or sexual assault. We can do that by adopting my amendment, and I urge my colleagues to support it. I yield back.
The clerk will reread the amendment because I'm concerned that Mr. Raskin's amendment was read, not Mr. Swalwell's.
Sorry?
When she read the amendment, I think she did not read your amendment. So.
Amendment to the amendment in the nature of a substitute to H.R. 1215 offered by Mr. Swalwell of California. Page 12, line 7, strike or which.
Without objection, the amendment is considered as read. For what purpose the gentleman from Iowa seek recognition?
Mr. Chairman, I move to strike last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment should be defeated. If members want to see that women have better and more accessible medical treatment everywhere, this amendment should be defeated here in this committee today and have the base bill be supported. Women pay an especially high price when it comes to medical liability and access to care. That's why the American Congress of Obstetricians and Gynecologists supports this legislation. Without medical liability reform, women and their families face ever-increasing costs that cause healthcare expenses to overwhelm their household budgets. Standard liability insurance rates for Long Island obstetrician gynecologists are approximately $179,248 each year. But the rates in Central California, where effective medical liability reforms are in place, are a fraction of that. A medical liability provider in the state, the Cooperative of American Physicians, quotes $16,000 for OBGYN for a region of counties that includes San Francisco. A recent study discovered that 2013 was the first year since 2003 that there was actually an increase in nationwide in both total payout amounts and total number of payouts in liability cases, a large driver of healthcare costs. Not coincidentally, per capita payouts in New York and Pennsylvania, where no reforms are in place, are now more than 12 and 8 times higher, respectively, in comparison to Texas, which has actually effective reforms. Analysis of efforts to raise the reasonable limits on non-economic damages in California estimated that liability premiums would increase up to 38% based on the experience of other states that have imposed or eliminated limits. California's annual health costs would rise by $9.9 billion, or $1,000 for a family of 4. Why should rape victims have less access to doctors than others who receive when they're injured under this bill? They shouldn't. They should get the same protections afforded everyone under this bill. I urge my colleagues to join me in opposing this amendment, and I yield back the balance of my time.
Mr. Chairman,
Purpose the gentleman from Michigan seek recognition.
I arise to strike the requisite number of words.
Gentleman is recognized for 5 minutes.
Thank you. My colleagues, the Swalwell Amendment exempts from the bill cases concerning treatment of injuries caused by rape or sexual assault. I support this amendment because victims of either of these crimes are among the most vulnerable of crime victims. The last thing they should be worried about is receiving substandard and negligent medical treatment for their injuries resulting from either rape or sexual assault. Yet, H.R. 1215 imposes numerous obstacles in the way of rape and sexual assault victims who are victimized a second time by poor medical treatment of their injuries. These include an extremely low cap on non-economic damages, which has a particularly adverse impact upon women, the poor, elderly, and children, because these groups are more likely to suffer non-economic damages like pain and suffering and loss of consortium. The bill also immunizes healthcare providers from lawsuits concerning defective or dangerous drugs or medical devices. It also eliminates joint liability, making it less likely that a victim who suffers irreversible injury will be able to recover the full amount of damages owed to her. So while H.R. 1215 is fundamentally flawed, adopting this amendment will make a bad bill a little better and help avoid victimizing rape and sexual assault victims a second time. So I urge my colleagues to join me in the adoption of this amendment, and I thank the chair.
Mr. Chairman.
Purpose of the gentleman from Georgia seek recognition.
Move to strike the last
Gentleman is
word.
recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in support of the Swalwell Amendment, which protects rape victims, sexual assault victims from the harsh denial of justice that they would suffer if this underlying legislation is passed. And I would note that my colleague from Iowa has talked about the costs to the healthcare system and the access to the healthcare system that is impeded by those costs. But I would point out that my colleagues on the other side of the aisle are united in wanting to repeal the Affordable Care Act, which they derisively call Obamacare. They want to repeal it. It makes health care more affordable. It has enabled 30 million people, when you factor in Medicaid coverage expansion, it makes health care accessible by 30 million, for 30 million people, but they want to repeal the Affordable Care Act instead of repair it. That's been something that they've been talking about for 6 years. And out of 6 years, we get to the time where we've got Republicans in control of the House and the Senate and the President. We've gone 40 days into this session and still don't have a piece of legislation in place offered by my friends on the other side of the aisle to repeal and replace. So if you're going to repeal and replace, you've got to introduce some legislation. There's not been one piece of, not even a sentence offered in the House of Representatives or in the Senate to repeal and replace. And if you're going to repeal, all you got to do is say, legislation, just one line. We officially repealed the Affordable Care Act, also known as Obamacare. Boom. Take a vote on it and it's done. But the reason why they don't want to do that is because they know that it will hurt Americans. They know that it will deprive Americans of their ability to access the healthcare system, 30 million of them. And it'll also hurt the millions of others whose benefits were made better by the Affordable Care Act. In other words, no bans on pre-existing conditions, no lifetime caps, no yearly caps, free annual wellness checkup, all of the closing the donut hole for prescription drug prices that have hurt our seniors so badly over the years. These are the ways that we have protected the ability of people to access the healthcare system. And I laud my friend from Iowa for talking about accessibility and affordability of healthcare, but tort reform is the exact wrong way to go about doing that. Tort reform protects the pocketbooks of malpractice insurance companies, of big healthcare conglomerates, of health insurance companies. It protects them, but it protects them by taking away your right to be able to seek redress when there is medical negligence that occurs to you and your family. You'd be barred under this legislation significantly from being able to pursue your just claims. And the reason why is because it doesn't benefit the big insurance companies for you to do that. So it's not really a matter of anything other than protecting big business at the expense of consumers. And I would just ask my colleagues to think about what we're doing with this legislation. We could be spending time passing a jobs bill, passing regulations to protect the health and safety of innocent women, children, babies, elderly, but instead we're trying to snatch rights away that are guaranteed under state law and have been guaranteed by federal law. With that, Mr. Chairman, I yield back.
Mr. Chairman.
The chair would advise the members that there is a vote on the floor. We can complete this amendment, hopefully, before that. And the chair would advise all members that because the motion of the gentleman from New York, Mr. Nadler, must be completed tonight, we will be returning here after the president's address, if necessary, to complete that markup. Gentleman from Rhode Island is recognized for 5 minutes.
Thank you, Mr. Chairman. I yield to the gentleman from California.
Thank you, Mr. Cicilline. And Mr. Chairman, my colleague from Iowa has pointed out how progressive California is, and as an Iowan who moved to California, I appreciate that. And I hope in future hearings we will see my colleague bring forward other pieces of legislation that have come out of California, efforts to tear down walls that impede freedom, like the walls we tore down that existed between a woman and her right to make her own health care decisions. I welcome any efforts by the gentleman from Iowa to come forward and help tear down any walls that exist between a new American and their right to have a driver license. In California, we've torn down any walls that exist between a sick and dying patient and their right to have access to medicinal marijuana. In California, we have torn down walls that exist between a refugee seeking violence or certain death and the welcoming arms of people who believe they belong here in our country. In California, we've torn down walls that have existed between a family's right to have clean air and clean water and many of the giveaways to the oil and gas industry that have stood in their way before. In California, we've torn down walls that have existed elsewhere in this country between a person's right to go to the ballot box and not have to be impeded by unnecessary voter ID laws. In California, there is no wall between a worker and their right to organize. In California, there is no wall between a community's right to have sensible background checks and gun laws and the right to live in a safe community. In California, we have a $15 minimum wage. In California, we have sentencing reform in our criminal justice system. And in California, unlike here under our federal system, there is no wall that exists between a woman and her right to be paid the same as a man. So if the gentleman from Iowa is interested in continuing to pursue California legislation, I just laid out a number that you can pursue and that would not impede the freedom of all Americans. I yield back.
Mr. Chairman,
The
rise to strike the last word.
gentlewoman is recognized for 5 minutes.
Rise to strike to support the gentleman's amendment, Mr. Swalwell. And I appreciate very much the litany of state-initiated initiatives from California based upon states' rights. We have unfortunately not been able to overcome that hurdle in this bill. But I think one of the most devastating continued insults is the disparate treatment, except for the Affordable Care Act, of women as relates to the criminal justice system in some instances and medical care. And so I rise to support the gentleman's amendment because this bill does not provide the protection. It does not exempt women who are in fact being treated for injuries resulting from sexual assault or rape. It does not carve out that distinction so that they would not be blindsided by this legislation, which seeks to limit actions in state court and block damages on a federal level through federal law that may be legal and responsible in the state. How many times have we been in this committee discussing the unequal treatment of rape kits? How many of us remember the passage of the Violence Against Women's Act? It is not something that happened 50 years ago, it happened recently. So I think the gentleman has a very meritorious amendment, and it should be exempted for faulty medical treatment for injuries resulting from sexual assault or rape. And I believe this underlying legislation does not protect women in that instance, and that this is a needed amendment, and I'd ask my colleagues to support the Swalwell amendment. I yield back.
Question occurs on the Swalwell amendment. All those in favor respond by saying aye. Aye. Those opposed, no. Being the chair, the noes have it. The amendment is not agreed to.
Mr. Chairman, recorded vote, please.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers? Mr. Nadler? Mr. Conyers votes aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Mr. Schneider? Mr. Schneider votes aye.
Gentleman from Arizona.
Mr. Franks votes no.
Gentleman from Pennsylvania. Gentleman from Idaho.
Mr. Labrador votes no.
Gentleman from Illinois.
Mr. Gutierrez votes aye.
Gentlewoman from Washington.
Ms. Jayapal votes aye.
Has every member voted who wishes to vote? Clerk will report. The gentleman from Florida.
Mr. Deutsch votes aye.
The clerk will report, and while she's tabulating that, I'd advise all the members that we have a vote on the floor with 7 minutes remaining. We will reconvene immediately after this vote series to continue our work.
Mr. Chairman,
continue.
13.
Clerk will report.
Mr. Chairman, 13 members voted aye, 17 members voted no.
And the amendment is not agreed to. For purpose, the gentleman from New York is agreed.
Mr. Chairman, so I just want to clarify that there's an amendment, there are two votes on the floor. That should take about 15 or so minutes. We'll reconvene then. There's one amendment left on this bill, so we'll probably get to the resolution that all these people have been waiting for in 40 minutes.
Hopefully. Sooner the better.
Keep hope alive.
Committee will stand in recess.
Department of Justice to further that investigation. I know that there's resistance to this proposal. Many of my colleagues don't want us to investigate President Trump or his associates. Perhaps they're unconvinced by near daily reports of outgoing contact between the president's advisors and the government of Vladimir Putin. Perhaps they agree with the president's belief that conflict of interest laws do not apply to this office, although I note that this resolution makes reference to the Foreign Emoluments Clause and to 9 federal statutes that clearly apply to the president and prohibit some of his current behavior. Perhaps my colleagues simply hope these problems will go away, but they will not go away. And I believe that we have a responsibility to our constituents and to our Constitution to ask these questions until they are fully and satisfactorily answered. Each one of us has taken the oath to support and defend the Constitution of the United States against all enemies, foreign and domestic, and to faithfully discharge the duties of the office. The resolution before us is an opportunity to be faithful to that oath, to do the jobs we were put here to do, and get to the truth of the matters at the Department of Justice. And I think and wonder how history will judge us here today. I urge my colleagues to support the Nadler resolution, and I thank the chairman, and I yield back.
I now recognize myself for purposes of offering an amendment. The clerk will report the amendment.
Excuse, Mr. Chairman, don't I get to speak before you offer an amendment?
You'll be considered under the 5-minute rule as soon as this is offered. Clerk will report the amendment.
Amendment in the nature of a substitute to H.Res 111 offered by Mr. Goodlatte of Virginia. Strike all after the resolved
Without
clause.
objection, the amendment will be considered as read, and I will recognize myself to explain the amendment. I'm offering this substitute amendment to House Resolution 111 for 2 reasons. First, it corrects a technical error in the underlying resolution. The resolution as introduced cited an incorrect statutory provision. Rather than citing the code section prohibiting gifts to federal employees, the introduced version of the resolution cited the code section prohibiting the habitual use of intoxicating beverages to excess by members of the competitive service. My amendment changes the resolution to reflect the proper citation. Second, offering this substitute amendment preserves the majority's ability to ensure that the markup of this resolution proceeds smoothly and without dilatory tactics. Under the rules of the House, the previous question can only be called in order to proceed immediately to a vote on an amendment. By offering a substitute amendment today, I am reserving the right to exercise this procedural motion. Let me be clear. I do not believe I will need to exercise this procedural motion, and I intend to give members sufficient time to debate this resolution. However, offering this substitute preserves the ability to exercise this motion should the need arise. I'm now happy to recognize the gentleman from New York, Mr. Nadler.
Thank you, Mr. Chairman. Before I begin, let me just observe that we voted the previous question twice today, I believe for the first time in about 10 years. And I hope that the use of the previous question will not be used to shut off debate, reasonable debate on this proposal. Mr. Chairman, each day more questions arise concerning President Trump's foreign business entanglements and his inexplicably cozy relationship with Russia. Each day, Democrats on this committee and on other committees have requested hearings and investigations into these serious issues. And yet each day, with a few exceptions, we have been met with a deafening silence from our Republican colleagues. That is why I introduced this resolution, which directs the Department of Justice to provide the House of Representatives with any and all information it possesses related to any conflicts of interest, any ethical violations, and any improper ties to Russia by President Trump or his associates. This resolution is particularly important because Attorney General Sessions, who was involved in the Trump campaign, has refused to recuse himself from any investigation, and it is not clear that he could be impartial or that he will even conduct an investigation at all. Recognizing Mr. Sessions' obvious conflict, one of our own colleagues, Mr. Issa, has called for a special prosecutor, but the White House has dismissed that idea, essentially saying, trust us, there's nothing there. Well, that should not be good enough for this House. We must ensure that we get access to any information the Department of Justice has so that we can do our own investigation. We also recently learned about coordination between the White House and the chairman of the House and Senate Intelligence Committees, which calls into question the impartiality of those committees' investigations. Our committee must step up and ensure that there is a thorough and objective investigation of these serious issues. With respect to President Trump's breathtaking web of business entanglements, which he has refused even to disclose, here are just a few of the many questions that demand further explanation. Just blocks away from the White House sits the Trump International Hotel, on which the president is both a leaseholder through the General Services Administration and the lessee through the Trump Organization. How does this not represent a clear conflict of interest? There have been reports that foreign diplomats are booking rooms at this hotel as a means of currying favor with the president. To what extent do these and other payments to his properties from foreign governments constitute violations of the Emoluments Clause of the Constitution? The president owns properties, most of which bear his name, in dozens of countries. Is he trading policy favors for access to permits or other government benefits in these countries? We already recently saw China award the president a long-sought trademark shortly after he reaffirmed the One China policy, which he had appeared to question. Could the United States policy toward China be subject to the financial needs of the Trump Organization? How much of the hundreds of millions of dollars in debt on Mr. Trump's properties at home and abroad does he owe to foreign government entities like the Bank of China? And what sort of leverage over the United States does that provide to those governments? The questions go on and on. Breaking with decades of tradition and the advice of a bipartisan array of ethics experts, Mr. Trump has refused to divest his assets and place them in a blind trust. Moreover, he has even refused to release his tax returns, as all presidents have done for many decades. In the absence of this basic level of transparency, it is essential that we get more information on his financial picture and on how it may affect government policy. The other aspect of this resolution seeks information on the troubling ties between Russia and President Trump, as well as some of his close aides. Once again, the questions multiply by the day. Despite the unanimous agreement among the intelligence services that Russia hacked the Democratic National Committee and released documents intended to sway the election in favor of Donald Trump, why was he so reluctant to accept this conclusion? We know that top Trump aides were in communication with senior Russian intelligence officials over the course of the campaign. What did they discuss? What did White House Chief of Staff Reince Priebus say to the FBI to get them to downplay the seriousness of these charges? Did he violate any laws or norms by doing so? More broadly, President Trump has shown no hesitation in challenging and insulting foreign leaders, even leaders of our allies like the leaders of Mexico and Australia and friendly nations like Sweden. Why then does he refuse to say a single unkind word about Vladimir Putin, who murders his opponents, invades the Ukraine, and has interfered in our elections, just to name a few concerns? Does President Trump simply admire Mr. Putin? Does he not understand the threat that Mr. Putin poses? Or is there something more sinister going on? Between Mr. Trump's potential conflicts of interest and the potential coordination with a foreign power to interfere with our elections and with our government, then the security and integrity of our nation are at stake. It is unfortunate that we must resort to a resolution of inquiry to learn the truth about these serious issues. However, the House has so far abdicated its constitutional responsibility to provide meaningful oversight into the Trump administration, and it is time that we do our duty. This resolution does not prejudge the outcome of any investigation. All it does is provide us with some of the information we need to draw our own conclusions. The public deserves to know the truth about the president, and we must not stop until we get these answers. More than 130 members have co-sponsored this resolution, including every Democratic member of this committee. We have gotten phone calls from tens of thousands of our constituents who support it, and I've received over 835,000 signed petitions calling on us to pass it. They expect their representatives in Congress to help them discover the truth. I hope this committee will take the first step today rather than bury our heads in the sand. I urge the committee to report this bill favorably, and I yield back the balance of my time.
Committee will be in order. For what purpose the gentleman from California seek recognition?
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, and I thank my colleague from New York for citing what has been widely reported. As the gentleman from New York knows, there is no such thing as a special prosecutor. There is, however, a set of laws and regulations that allow for the Attorney General to conduct his oversight, and if there is a conflict, to resolve that conflict by appointing an individual who is outside the conflict. Additionally, the Attorney General may choose, if he sees fit, to recuse himself. But I want to give the gentleman from New York a quote from my classmate in Congress. I came into Congress with Adam Schiff, now the ranking member of the Select Intelligence Committee. Yesterday, Adam Schiff on CNN said, and I'm quoting from the underlying screen, but I listened to it personally, he said, "We don't yet know if Russia and the Trump camp had contact." I think it's extremely important that we listen carefully to what the highest-ranking Democrat on the committee that has the access to much of what most of us on this committee currently do not. He didn't say there may not have been contact. He didn't count out the fact that there's more to do. Ranking Member Schiff made it clear he has more questions, and he intends to ask those questions. I, for one, will support and push and ensure that his questions are answered. As the chairman of the committee said in his opening remarks for this response, there is a letter that is in draft form that I have already looked at and made my comments on that asks for information and cooperation by the Attorney General. That is fitting and appropriate as the first step. During my tenure as the chairman of another committee, I issued over 2,000 letters. Virtually without fail, my investigations began with letters. Letters that asked to preserve documents, letters that made people aware that Congress was interested in something that had been reported. And since I said reported, let's remember that much of the inquiry going on is not directly related to the events of information from the Democratic National Committee being made public. It's based on allegations that there was a connection to people working in the Trump campaign. If so, it is serious, and I, for one, will insist that Congress do its job. Each committee of Congress that has jurisdiction must do its job, and this committee more than any other committee, oversees the Department of Justice, and we have a responsibility to look over their shoulder and ensure they are doing their job. The chairman has wisely suggested differently than the gentleman from New York. And I might note, just for the record, that this bill or this inquiry was launched on February 9th. And for those who don't know it, that happened to be the day the Attorney General was sworn in. It was his first day. He's been around a while. I'm sure he knows a little bit about the Department of Justice. But it is very clear that the first thing you give to an Attorney General when you want information is not to file something in Congress in hopes that a non-binding inquiry letter will somehow make a difference. So I, with the utmost of respect for my colleagues, both here and on other committees, would ask that we use the system first, that chairman and ranking members jointly, and hopefully with as many members of both sides of the aisle, go forward with letters that are united, that ask for information and cooperation necessary to know more than we know today. And I particularly ask for this because the problem is big. The problem of Russia, to my understanding, is a country that has used their technology around the world, but particularly by their close neighbors, to distort those democracies, to distort their freedom.
Would the gentleman yield?
I will in just a second. And if they have attempted to distort our democracy, we must know it and we must stop it. I would be happy to yield to the gentleman.
Thank you. I would ask if the gentleman has read any of the letters that we have written, that Mr. Conyers and I have written to the chairman asking for investigations. This resolution was filed because we've gotten no replies to any of the letters we've written since January.
Well, in reclaiming my time, I have read some of them. I have not necessarily seen all of them for obvious reasons. I personally have talked to the chairman. I personally have been involved in trying to structure a letter to the Attorney General. I would ask that as soon as it's made available, I know it's in final draft, that we all look and ask the question, if the letter asks for the information we want and for ongoing cooperation, and if we trust our chairman and ranking members to honestly do what we've agreed to ask them to do, shouldn't we use that process? And if it fails, if we are not getting the cooperation we expect, I have a long history of limited patience. And I would hope that if the ranking member of my subcommittee does not trust my word, at least he would trust my actions and history, that I, if nothing else, am tenacious. And I will not tolerate an absence of cooperation, but I have not yet asked for that cooperation. I yield to the gentleman.
I thank my friend. As a sign of bipartisanship and good faith, I wonder if my friend from California would at least be willing in this forum to agree that whatever letter it is that we're hopefully going to send in a bipartisan way will include a request for every one of the items set forth in this resolution that we're debating right now.
If the chairman would give me just enough time to answer, I cannot say that, but what I can say is I want the full truth, and I yield back.
Mr. Chairman?
What purpose does the gentlewoman from Texas seek recognition?
To strike the last word.
Gentlewoman is recognized for 5 minutes.
I really appreciate my colleagues' thoughtful analysis. I think members of Congress have said many things, including members of a variety of committees that have the jurisdiction to have oversight over these issues. First of all, the letters have been cited already that we've sent. The dates have not been given, January 24th, November the 30th, and January 12th, 2017. So we've sent a series of letters. But as I read the Constitution, there are several elements. The first, Article 1, Section 1, says that all legislative powers herein granted shall be vested in a Congress of the United States. This is a legislative act in which we are engaging in to pass a resolution of an inquiry. I'd beg to differ on whether or not there is no basis in law for this resolution or that this resolution would not have legal impact. The language written by Mr. Nadler is precise. It asks that the Attorney General is directed to transmit, to the extent that such information is in the possession of the Attorney General, a list of information that deals with one constitutional element, the Emoluments Clause that is in the Constitution, happens to be in Article 1, Section 9, Clause 8, as indicated in the resolution, and as well the responsibilities that we have as a Judiciary Committee to deal with any concept, fact, or belief that there has been a direct intrusion by a foreign entity. We are the Judiciary Committee. Our responsibilities are vested in this document called the Constitution of the United States of America. The American people are in jeopardy. One approach, of course, is for the United States military to defend her. But if she is in jeopardy because of the spoiledness, the odor of government that does not protect the people's interests, the interest to be free from bias and special interests and money, the right to be free from free to have an unfettered government that is not overwhelmed by the intrusions of a foreign entity that will have the demise of the American people, not their best interests, then who then the bearers or the holders or the protectors of the Constitution legislatively, which is a Judiciary Committee, should not be engaged in this debate? Now let me be very clear. There is smoke and fire, so much so that I am overwhelmed. One of the unfortunate issues in this is the eagerness of the law enforcement agency to pronounce matters dealing with one candidate, but not pronouncing matters that dealt with another candidate. making an unequal election and denying one person, one vote, because that means the American people's information was lopsided. Secondarily, if I move to the emoluments clause, as I understand it, there is no trust, there is no blind trust with respect to business interests. The only thing we have is a word of mouth that other individuals will be governing those business interests. Does that involve the Trump Tower in Moscow? Does it involve the proliferation of the brand in hotels around the world, and particularly in the Mideast, if that is factual? How does it relate to properties, some of them commercial? They sell memberships. All we're asking is to undertake our legislative duty to pass this resolution, which is legislative, for it to go to the floor, which is legislative, to ask the Congress to stand on its two legs on behalf of the American people and say to them that it is not my interest, my self-servingness, but it is really my responsibility to let you see all of the documents that pertain to the ability of this government now to govern. I believe Mr. Nadler is correct in the approach. I believe that you would undermine and diminish our essence, our authority. My good friend from California, as I understand it, it was in the media, recommended a special prosecutor. That's an act of governing. Why then would we step away from the act of governing right now, which is to pass this resolution, pass it on the floor, and give the American people what they deserve? I yield back.
The committee will stand in recess until the completion of the votes that are currently scheduled. There's 9 minutes remaining in the vote on the amendment number 2. The committee will reconvene. When the committee recessed, we were considering the substitute amendment to House Resolution 111. Who seeks recognition? The gentleman from Florida seek recognition.
Well, Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.Res. 111 offered by Mr. Deutsch. Page 1, line 16.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. Mr. Chairman, members of the White House and the FBI, we know, have been in contact with each other during an open and ongoing investigation into the Trump campaign's contacts with Russian officials during the 2016 presidential election. In fact, White House Press Secretary Sean Spicer has confirmed the communications between the White House and the FBI, indicating that it was the FBI that initially approached the White House. Confirming that the FBI first contacted the White House, Press Secretary Spicer said, and I quote, "We literally responded to what they came to us with and said, okay, what are you going to do about it? Had we not done anything and just sat there, it would have been irresponsible and, frankly, malpractice," close quote. However, the communications between the White House and the FBI did not end there. In fact, Press Secretary Spicer has further confirmed that Chief of Staff Priebus then requested that FBI Director James Comey and FBI Deputy Director Andrew McCabe knock down numerous news reports describing communications between Trump's campaign associates and Russian officials during the 2016 presidential election. Any communication, no matter who initiates it, between the White House and the FBI raises significant ethical and legal concerns during an open, ongoing investigation. Indeed, any such communications between the White House and the FBI taints the ongoing investigation and suggests possible improper influence or meddling. Mr. Chairman, as this committee knows, contacts of this nature between the White House and the FBI also violate long-standing Department of Justice guidelines. My amendment, my secondary amendment to the amendment in the nature of a substitute, would ensure that we receive all documents and all information involving communications by White House officers or employees with FBI Director James Comey, FBI Deputy Director Andrew McCabe, or any other officer or employee of the FBI. In addition, my amendment would ensure that we receive the DOJ memorandum entitled Communications with the White House and Congress that was signed by then Attorney General Eric Holder on May 11, 2009, and any efforts since to revise or to replace it. This memo states that the Justice Department will advise the White House concerning any pending or contemplated criminal or civil investigations on cases when, but only when, it is important for the performance of the President's duties and appropriate from a law enforcement perspective. This memo still has the force of law unless the information requested in my amendment demonstrates otherwise, and there has been an effort to revise or replace that memorandum since January 1st, 2017. It's critical that our committee have access to the documents and information requested in this amendment. Failing to receive these documents will only serve to raise and to buttress doubts on whether the ongoing investigation into contacts between the Trump campaign associates and Russian officials during the 2016 presidential election has been tainted. Mr. Chairman, it is important that we receive all of the information contained in Mr. Nadler's resolution. My amendment would ensure that we receive the additional information regarding any communications between Reince Priebus, Sean Spicer, or any other officer or employee of the Executive Office of the President with the FBI Director, the FBI Deputy Director, or any other officer or employer of the FBI. It is information that we need to evaluate, and it is information that it is because this information is so necessary that I have offered this amendment, and I would urge my colleagues to support it. And with that, Mr. Chairman, I will yield back.
Mr. Chairman?
The chair recognizes himself in opposition to the amendment. I oppose this amendment, and I urge my colleagues to do so as well. The amendment inserts additional language into what is already an overbroad premature resolution. Among other things, it would call on the Attorney General to provide the contents of any communication between the White House Chief of Staff, Press Secretary, or any other executive office employee of the president employee with any FBI employee. This amendment is more of the same. It doubles down on our colleagues' efforts to short-circuit this committee's longstanding and legitimate oversight processes by casting an even wider net in hopes of discovering illicit activity. That is not the way appropriately conducted investigations happen. Again, the proper way to conduct oversight is to encourage the Department of Justice to enforce our criminal laws and, if need be, to resort to further measures. That is why I am sending a letter to the Department of Justice this week urging them to follow all legitimate investigative leads in these matters and to alert the Department of Justice that this committee will continue to conduct oversight in these matters. I urge my colleagues to oppose the amendment.
Mr. Chairman, I'd like to strike the last word.
California seek recognition.
Mr. Chairman, I want
Gentleman's
to...
recognized for 5 minutes.
Thank you. I want to support the amendment offered by Representative Deutsch. And like many of my colleagues, over the break, I had town halls that were attended by a couple of thousand of my constituents. Many of them are very concerned about the efforts of the administration in trying to influence the FBI, but they are also demanding an investigation of President Trump's ties to Russia, as well as demanding his tax returns. With these persistent questions hovering over the president, it begs the question, why isn't he seeking to resolve these vital questions and concerns? He has called for an investigation of voter fraud. As a private citizen, he demanded President Obama's long-form birth certificate. Back then, he would not take "trust me" as an acceptable answer. It's imperative that we thoroughly investigate any and all conflicts of interest, government ethical violations, or potentially illegal conduct and actions of the president and current or former members of his administration and transition team. In particular, it's incumbent upon this body to examine whether there were dangerous and troubling ties to Russia, which may have exposed grave threats to our national and global security and democratic integrity. And every day from the day Mr. Trump was sworn into the presidency, my office has been overwhelmed with calls, messages, and correspondence demanding that he release his taxes and to investigate his administration. President Trump has refused to step away from his business interest in any meaningful way. His foreign entanglements potentially are unconstitutional. He has repeatedly refused to disclose his financial assets and is clouded by the specter of Russian intervention in the election and his administration. We must know what the Department of Justice has learned about the administration's connections to the Russian government. We must review the department's legal analysis, if there is any, of the president's attempt to remedy his wide-ranging ethics problems. We must conduct the oversight of this administration. Thank you. I yield back.
For purpose, the gentleman from Illinois seek recognition.
To strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I would just simply say to my colleagues on the majority, if the president has nothing to hide, then let's clear up the air. And let's present the documents before the American people. We all have heard him state publicly that if there was someone who could make money off of being president of the United States, he would know how to make money off of being president of the United States. That's not something that we simply make up. That is something that he has actually said. Well, we want to know if he's making money off the American people and off of his public office. I think the American people deserve that answer. Look, it's been very clear. Even Richard Nixon gave us his income tax returns. Income tax returns that were under audit. We all know that unless we force and use the legislative branch of government to force the President of the United States, he will never release those income tax returns. And with not releasing those income tax returns, I think further and further it makes the American people more and more demoralized about their lack of trust and the lack of transparency that exists in the executive branch of government. I don't know what he does or doesn't own in Russia, but he sure does love Putin, and I would like to know why, and I would like to know what it is he owns there. You know, he says he's going to give back all of the money that he might earn from his interests. Well, isn't he already admitting that he can make money off of his interest? Why would I say that I will give back the money that I make from my hotels, but maybe not from other deals that you have? I mean, the very fact that he says that, I said, should lead us to all vote in the affirmative. I want to thank my friend and my colleague. I am very, very proud of Congressman Nadler, both for presenting this resolution and his for tenacity and pushing it forward. And apart from that, from being a classmate of mine when we arrived here in 1992. Look, it's time to do this. And you know, the majority members, let's be clear, you were tickled pink when Comey came and commented on the emails of Hillary Clinton. You didn't think it was time to wait for an investigation or that no one should comment. And when he commented again a few days before the election, you jumped up and down for joy. All right, well, this is not partisan politics. This is about the integrity that we should have. Lastly, let me just say this. Shouldn't the president have the same standard that we all as members of Congress, every last one of us, if we buy a single stock share of any stock, has to report it within 48 hours. We have to, at the end of the year, tell what homes we own, not only what we own, what our wives own. We have to be clearly transparent. This is the President of the United States who has said, and I repeat, if someone can make money off of being President of the United States, I can. I say we stop him from making money off the presidency of the United States, and we make this clear before the American people and transparent. Let the documents flow. Let air and sunshine reign, because that's what it should be. And we should be guardians of the Constitution and of the public trust, and not people who simply sit as lapdogs of anybody here. Let's make the truth be known to the American people. Thank you so much.
Mr. Chairman, I object. If this happens again, I would request that everybody be removed. This is not necessary. I can do whatever I want.
The gentleman will be escorted out of the hearing room. These kind of outbursts are not appropriate. You must restrain yourself and not applaud when members say things. That's simply not a part of this process. The gentleman from Tennessee is recognized for 5 minutes.
Thank you, Mr. Chairman. There's no question that many people in our nation are concerned about the activities of the president, his business entanglements, and his taxes. And the president said the other day, I haven't talked to Russia in 10 years. Although we know that that may be a serious falsehood, because he had a Miss Universe contest in Russia in 2013, but he said he hadn't talked to Russia. Well, you can't talk to a country, so we really don't know what he meant. But if there are records of his campaign having involvement with Russian intelligence officials, this country needs to know about it. And to say that it's premature, there are decisions being made on whether we should be giving the Ukrainian government weapons to defend their country from the folks in the eastern Ukraine who are being supplied by weapons from the Russians. If they are not being supplied the proper weapons to defend themselves, there are going to be people dying in Ukraine. And if the decision is being made not to supply those people because we have a deal with Russia and a relationship with Putin and we don't want to get involved in their particular situation, then it is eminently important that we find out as soon as possible, because there are human beings that are going to die because we are not taking action that we could and I believe should to defend NATO allies because of entanglements. There's just absolutely no plausible reason why the man would defend his taxes so much. I mean, the fact that he probably hasn't contributed much to charity, people pretty much know that. The fact that he isn't as wealthy as he claimed he is, people pretty much recognize that. The fact that he didn't pay taxes on $1 billion, we already know that. So what's left? What's left is who he has loans from and who that involves. And if there are loans from, and his son said, I think in 2008, we have lots of investment from Russians, and if it weren't for those investments, we'd be in trouble, then he's being controlled by people who've made loans to him to keep his businesses afloat. And we need to know that, because that would interfere with his activities. Russia is not our friend. In no way they are our friend. They don't have our values, and they do not pursue activities that are consistent with a free and open and democratic Europe. And that's important for the United States to have relationships with the countries in Europe, and that they are supplied with information and that we help defend them. I just can't see where the harm would come, Mr. Chairman. I appreciate your letter, but in your letter, I think if I remember correctly, it referred to looking at the leakers. And, that's not on the same level. The people making these leaks probably are doing it because they think it's important for America's future and that there's information that needs to be known. That's not consistent with information that could be found out about Russia having an influence over our president because of business ties or other reasons that are affecting our policy, or actions during an election that could be considered treasonous because they were working with the Russians to affect our election. I was recently in Vienna, and we met some members of the Duma, and one of them said, "Oh, we didn't hack your elections. That's not true, and it'll be seen in the future." Well, that's the Russian line. Talk about siloed. They are so siloed, and they do not in any way whatsoever understand. Now, this resolution, Mr. Nadler has done us a service by bringing the resolution. If the Attorney General has information, and I can't imagine he doesn't, because this information, what we've seen in the press, they've had information since October at least about possible contacts between Trump, election officials, and Russia. And the FBI and intelligence people were allegedly looking at that as far back as October. So there must be, because they notified the president and they notified others back, I think it was October, or maybe earlier than October. So they've got information that they could communicate to us, and if they have information, if it's shown to us in a classified setting, there's no harm. If there's nothing there, wonderful. He can say, just like Richard Nixon, I'm not. But we need to get the information to satisfy the American public that America is really, truly America first, and that we look out for our American interests. I yield back the balance of my time.
What purpose does the gentleman from New York seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Let me first just thank my distinguished colleague from New York, Jerry Nadler, for putting forth this resolution of inquiry, as well as my colleague from Florida for his secondary amendment. On November 17th of 1973, Richard Nixon, the President of the United States, made the point that the people of America deserve to know whether or not their president is a crook. That was in connection with the Watergate scandal that eventually led to his resignation in disgrace. But it began with a simple break-in of the Democratic National Committee headquarters in the summer of 1972. And if you compare that simple break-in, which led to the unraveling of an administration, to the facts that we have today, I'm wondering why my colleagues on the other side of the aisle refuse to support a thorough, vigorous investigation into what possibly had gone wrong. Because this didn't begin with just a simple break-in. 17 different intelligence agencies have concluded that the Russians interfered with the election for the purpose of helping to elect Donald Trump. Apparently, that's not sufficient. We know that going as far back as December of 2015, there were high-level contacts that were likely made between close Trump allies and Russian intelligence agents. Not diplomats, but Russian intelligence agents at the same time that the hacking was taking place. Carter Page, the top foreign policy advisor to Donald Trump, appears to have been involved. Paul Manafort, the campaign chairman, appears to have been involved. Michael Flynn, who subsequently became his national security advisor, appears to have been involved. Roger Stone, a longtime Trump confidant, appears to have been involved. What do we think they were talking about with those Russian intelligence agents? Vodka? Chess? At the same time that the hacking was taking place. Apparently, that's not sufficient. We also know that the law was likely broken by Michael Flynn in December of 2016 because of his illegal contact with the Russian ambassador, talking about sanctions that were imposed as a result of the hacking of our election, which subsequently led to him resigning in disgrace. But before he resigned in disgrace, he lied to the Vice President of the United States of America, who then took that misinformation and lied to the American people. But apparently, that's not enough for my colleagues on the other side of the aisle. We also know that the president refuses to disclose his taxes. What exactly is he hiding? What will those taxes show about entanglement with Russian business interests? These seem to me to be reasonable questions. And at the same time that he attacks allies like Mexico and Australia and NATO and the European Union, and most recently, France, nobody seems to escape his ire, with the exception of Vladimir Putin. It appears that this president is determined to make the Kremlin great again. Why can't he say a negative thing about Vladimir Putin when he shows no restraint with respect to anyone else in the foreign policy realm? And then his chief of staff tries to interfere with the FBI, raising the question of obstruction of justice. The American people deserve to know whether or not their president is a crook. I yield back.
For what purpose does the gentleman from Florida seek recognition? Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. And the chairman's opening remarks in this instance were accurate. This is just about politics, and the hyperbole is thick enough to cut with a knife. This isn't about investigation. In a true investigation, you don't prejudge the outcome before it occurs. And all of the rhetoric we've heard from our friends on the other side of the aisle does prejudge those outcomes. It's certainly not about oversight. We have already, as a Judiciary Committee, amended our oversight plan to include a thorough review of that which is under our jurisdiction relating to the executive branch. As a matter of fact, we amended that oversight plan as the result of the chairman accepting a Democratic amendment to do so. It was a sign of bipartisanship, and it was an institutional move for this committee. In fact, what we are witnessing is that President Trump's detractors are going through the stages of grief because Hillary Clinton lost and Donald Trump won. The first stage of grief is denial. That was first on display when House Democrats made baseless claims to invalidate Electoral College votes. Talk about an attack on democracy. House Democrats stood up and tried to invalidate votes cast in the Electoral College. Their claims were so ludicrous that they couldn't find one Democrat member of the United States Senate to join them. Not even Senator Sanders, not even Senator Warren. Baseless claims solely as a consequence of denial. The second stage of grief is anger. And anger is okay. Republicans were angry after 8 years of failed policies, a doubling of the national debt, and executive overreach. Matter of fact, Americans were angry enough over those consequences to give control in the White House, in the House of Representatives, and in the United States Senate to Republicans, presenting an opportunity for unified government and true leadership. Americans were angry, and that led to the Democrats' defeat. I don't know if this resolution is a manifestation of bargaining or depression. What I do know is the Democrats need to get over it. The people have spoken, and this is the time for acceptance. We need to accept the fact that the American people want tax reform, regulatory reform, a rebuilding of our military, healthcare solutions that increase choice for all Americans. This is our job, and we will do it. And so, as we proceed forward, supporting Chairman Goodlatte's efforts to send a letter to the Attorney General to ensure that the law is fully complied with, let us know that only through acceptance and closing these stages of grief can we work together on the challenges facing the country with the majority leading and the minority being heard from in a meaningful way. That will make America great
Will
again.
the gentleman
and
yield?
I yield back.
Will the gentleman yield?
Mr. Chairman.
Will the gentleman yield?
Certainly.
Appreciate the gentleman's point about acceptance. And does the gentleman accept that he said 2 weeks ago that the president should show his taxes?
Reclaiming my time, if I were the president, I would release my tax returns. And the reason is we ought to be past this issue and moving to the great challenges facing the country. But the president's under no obligation to do that. And certainly the work of this committee would better be served on that which is within our jurisdiction to improve the quality of life for Americans. This will do absolutely none of that.
Thank you for yielding.
What does the gentleman from Michigan seek recognition?
Strike the last word,
Gentleman is
please.
recognized for 5 minutes.
Members of the committee, I hope that my colleagues will support this important update to the Nadler resolution. Thank you, Gerald, for your work several weeks ago, when we could not have anticipated that the White House Chief of Staff would get caught asking the FBI, and I'm quoting from the initial CNN report, to, quote, publicly knock down media reports about communications between Donald Trump's associates and Russians known to U.S. intelligence during the 2016 presidential campaign, end quotation. As Mr. Deutsch has pointed out, if they indeed took place, those communications are totally inappropriate. And I'm particularly concerned given that several people in the White House appear to be the target of the underlying investigation. This committee ought to get to the bottom of the matter. We can do it, members of the judiciary. That begins by asking Attorney General Sessions for this basic information. And so I urge my colleagues to support the Deutsch amendment, and I yield back the balance of my time.
For purposes, the gentleman from New York seek recognition.
Strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, my statement and the resolution that I offered, which is under consideration, was very clear that we were asking questions based on information that has been well reported. It does not prejudge anything. It asks for information to lead us to see where it goes. It asks for that information because, given the fact that the Attorney General has refused to recuse himself, and he's perhaps, he was certainly involved in the Trump campaign, and perhaps an object investigation, we have to make sure that the material is not compromised, and that we have possession of the information. I commend Mr. Deutsch for broadening, for his amendment, broadening the resolution in a constructive way. But the fact of the matter is that, you know, aside from Mr. Gates' psychoanalysis about the stages of grief, I'll put that to the side. The fact is, Mr. Trump is the President of the United States. No one denies that. But there are very serious questions, not only about his collusion with the Russians, possibly, not only about the Russians' demonstrated involvement in our elections and the possible collusion of the Trump campaign in that, which we must know about. I'm not saying it happened. It may have happened. That's what we have to find out. And the fact of the matter is that we did send letters to the chairman before this resolution was drafted, asking for investigations. We never got a reply. Now, I'm glad to hear for the first time today that the chairman is drafting a letter to the Justice Department or the FBI. I'm glad to hear that. It'll be interesting to see if it's as comprehensive as we think it ought to be. If it is, we'll certainly, if invited, sign it. But meanwhile, this resolution is apropos and especially apropos since we had heard nothing about any investigations prior to this. So I urge I commend Mr. Deutsch for his amendment. I urge its adoption. And again, I urge the adoption of the amendment. And if the gentleman is asking me to yield, I'll yield to him.
Please, thank you. Just want to ask you a question. As an individual who's gone through grief recently, if you go through stages of grief and you thought somebody that was close to you was murdered, do you just accept it and move on, or do you go back and want an investigation to find out who murdered your loved one?
Well, let me put it this way. I have gone through grief recently. My mother, as you know, passed away at 97, but no one thinks she was murdered. So I have no experience with that.
Well, but if it was the case, you would. And the fact is, the election was, the Russians hacked Mr. Podesta.
Well, reclaiming my time, the Russians, we know, attempted to influence the election. Presumably they had some influence. Whether that was enough to actually affect anything is unknowable. But they had ill intent. They tried to influence our election. We have to make sure that doesn't happen again. We have to find out how it happened, if anybody colluded with them in making it happen. We have to protect the integrity of our democracy.
Mr. Chairman?
For what purpose the gentleman from Rhode Island seek recognition?
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I support strongly the Deutsch amendment as well as the underlying resolution. I do think it's disappointing that some of our colleagues would describe our effort to defend the integrity of our democracy and our political institutions as being just about politics. Indeed, it's very sad to me that something as serious as the allegations that we're focused on here would elicit that sort of a description. I want to first say that the notion that we should either pass these resolutions or send letters and that we somehow have to pick the two, I say we should do both. And that would underscore the seriousness of our effort. I'd ask unanimous consent that the 5-page letter sent by all the Democrats from this committee to the chairman dated November 30th, and the 5-page letter dated January 24th to the chairman signed by all the Democrats requesting the same kind of information be made part of the record.
Without objection, they will be made part of the record.
There's also been a suggestion that we've adopted an oversight plan, and we've already included that we're going to do this in our oversight plan. That should be enough. We're done. But of course, the adoption of that oversight plan mandates that we begin the work of doing oversight, and this resolution of inquiry is the first step to gather information, to ask questions. Last summer, I asked President Obama to cut off candidate Donald Trump's access to classified information. That was at a time when he encouraged the Russians to hack the private emails of a presidential candidate, while he was heaping praise on Vladimir Putin, a dangerous and brutal dictator. Letters have been written, legislation has been introduced, and public calls for investigations have gone unanswered. The American people need to have confidence that their government is acting in their interests, free from foreign interference or any personal or business conflicts. Confidence in this regard is essential to the survival and functioning of our democracy. I, like many others, was very disturbed by the relationship between then-candidate Donald Trump and Vladimir Putin. And since then, we've learned much more about Donald Trump's ties to Moscow. 17 of our intelligence agencies reported that Russians, at the direction of Vladimir Putin, engaged in a wide-ranging effort to help make Donald Trump the president of the United States. We know that his top aides, including his campaign manager, Paul Manafort, had repeated contacts with Russian intelligence officials. We know his foreign policy advisor, Carter Page, came under investigation for his own ties to Russia. The president then appointed Secretary of State Rex Tillerson, who personally received the Russian Order of Friendship from Vladimir Putin. And we know Acting Attorney General Sally Yates told the White House that the president's national security advisor, Michael Flynn, posed a security risk because of his untruthful statements about speaking with the Russian ambassador about sanctions relief. She was subsequently fired by the president. And we know Michael Flynn resigned not because of his contacts with Russia, not because he lied to the vice president of the United States and to the American people, but because the facts of those incidents were made public. President Trump has refused to divest his ownership interest in his holdings and continues to keep his tax returns secret. And that's what this resolution is designed to get at. It asks Congress to fulfill its responsibility of oversight of the executive branch. That's how our system works. But in order for us to carry out that oversight function, we need to get information. And passage of this resolution is the beginning of gathering information and fulfilling our constitutional oversight responsibility. And so we're asking the Attorney General to share with Congress any information that the Department of Justice has on the president's ties to the Kremlin his ethics violations, or his conflicts of interest. Donald Trump may be our president, but he is not above the law. So I urge my colleagues to join us in this effort. The examples of conflicts of interest are too numerous for me to mention in my remaining time. But we know that President Trump has sought and received funding for his business from Russian financiers. Donald Trump Jr., who presumably manages day-to-day business operations for the Trump organization, has confirmed, and I quote, that Russians make up a pretty disproportionate cross-section of a lot of our assets. These facts are a cause for concern in many respects. And that's what he said in September 15th of 2008. The Industrial and Commercial Bank of China, which is owned by the People's Republic of China, is the largest tenant in Trump Tower. It's also a major lender to the Trump Organization. Its lease is slated to end in October of 2019, and the bank's rent payments, its ongoing extension of credit to the president's business, and any financial benefit that may accrue to President Trump during renegotiation of that lease also appear to constitute a foreign emolument. Foreign diplomats and other representatives of foreign governments have been encouraged to move their business to the president's Washington, D.C. hotel. At least one report suggests that a foreign embassy was pressured to move their event to Trump property, and now we learn, according to the Washington Post, they actually hired a director of diplomatic sales to make good use of this. These all raise very serious questions. And so I urge my colleagues, put country above party. This is not about Republican or Democrat. This is about preserving the sanctity of our democracy, satisfying the American people that we take this responsibility seriously and get to the bottom of this and have these questions answered. And with that, I yield back.
Mr. Chairman. The gentleman has expired. For purpose, the gentleman from Iowa seek recognition.
To move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I rise in opposition to this amendment. I've listened to a whole string of misstatements by the other side, and my central message is that this committee must avoid reacting, knee-jerk reactions towards rumors and innuendos. We should be dealing on facts. And I hear these things stated as facts, among them that the Russians hacked into this intel, and that it's a universal position on the part of the intelligence community, 17 members of the intelligence community. And I will tell you, that's the Obama intelligence community that they're referring to. But I have in my hand an article, it's printed by CIA veterans, and the headline is this: veterans urge caution on leaks saying Russia's Putin tried to get Trump elected. The caution on those type of leaks. It says, and I quote from this article, a senior FBI counterintelligence official reportedly scoffed at the CIA's conclusion that Russia had plotted to put Trump in office, calling the evidence fuzzy and ambiguous. And in another article titled U.S. Intel Vets Dispute Russian Hacking Claims, it identifies, as it says, we have gone through the various claims about hacking. For us, it's child's play to dismiss them. The email disclosures in question are the result of a leak, not a hack. And here's the difference. A leak is when someone physically takes out of the organization data and gives it to some other person, such as Edward Snowden or Chelsea Manning did. And a hack is when someone actually in a remote location electronically penetrates operating systems, firewalls, or any other cyber protection system and then extracts that data. So I would ask unanimous consent to introduce these two articles into the record, Mr. Chairman.
Without objection, they will be made part of the record.
Thank you, Mr. Chairman. And I would continue. That as near as we can tell, it's a leak, not a hack. But when I hear that it was spoken definitively that the Vice President of the United States lied to the American people, coming out of this committee, members of this committee, we sat on this committee with Mike Pence. Nobody that knows Mike Pence can deny the integrity of the man. And Mike Pence would not lie to the American people. He wouldn't lie to his wife. He wouldn't lie to anybody on this planet. That's who he is. And I would point out also, for informational purposes, Charlton Heston advised us during a re-election campaign of Bill Clinton what the difference is between a mistake and a lie. And he looked into the camera and he said, Mr. President, when what you say is wrong and you don't know that it's wrong, that's a mistake. When what you say is wrong and you know that it's wrong, that's a lie. And there's a big difference. And it troubles me when I hear that word liar hurled out in this way. We don't know that General Flynn directly lied to Mike Pence. We know there was a loss of trust, and that's acknowledged by everyone.
Gentleman yield.
And I won't yield. And furthermore, the allegation that there's some crime was committed If you're the appointed, person and advisor as he was, and you're not contacting foreign interests and not laying the foundation for those communications while you're waiting for the president to be inaugurated, you don't wait till January 20th. There's no indication there were any laws that were broken by General Flynn. So we should take a deep breath and let's get this down to their reality and not be hurling these accusations out. Another accusation that Donald Trump, we know that he didn't pay $1 billion in taxes. We don't know that. And furthermore, this search for his taxes, there's nothing in his taxes that are going to tell us what his loans might be if he has any or who his debt might be too. That's not part of the tax program. And furthermore, if we were to go through and answer every one of these requests that are coming out of the left side of the aisle today, answer every one of them, they would make sure that this Congress is immobilized until there's another president ensconced in the Oval Office. And I didn't hardly wait until he's inaugurated before this resolution comes forward. So this is about obstructing the flow of government, trying to render the presidency of Donald Trump ineffective, and trying to knock this agenda, the American people's agenda, off the rails. So we need to move on in this committee. We need to move on with the Trump administration. We have a nation to save. We have a rule of law to restore. We have a foreign policy to put back together. We've got a budget that's going to be a difficult time getting to balance. But the most important thing is, and I heard it said on the left side of the aisle too, we've got to protect the Constitution, and we've got to restore the rule of law. And we can only do that if we're honest with each other, if we stop playing political games, and if we're objective about the difference between facts and rumors. And you're seeking to act on rumors, and I won't yield.
Would the gentleman yield to me?
I am actually preferential in that, Mr. Nadler. I'm going to yield to the gentleman from California.
Thank you. Mr. Chairman, I ask unanimous consent that today's Washington Post article that is titled, "FBI Once Planned to Pay Former British Spy Who Authored Controversial Trump Dossier," into the record. And in it, what it does is it outlines during the Obama administration, the FBI had an ongoing investigation which continued. I'd ask to be placed in the record.
Mr. Chairman, I move
Without
to strike
objection,
yield
we
back.
made a part of the record.
Move to strike the last word.
The gentleman from California. No, Georgia.
Thank you, Mr. Chairman. I
Please
rise.
recognize for 5 minutes.
Thank you. I rise in support of the Deutsch Amendment, and I note how my friends on the other side of the aisle are trying to swim in the ocean with a giant anchor chained to their necks. That anchor is called Donald Trump, and how they are swimming feverishly trying to stay above water, but the anchor is driving them into the water, debilitating their vigor as every day goes by. The groundswell of support from the American people for an investigation into what 17 intelligence agencies of the United States have confirmed, that being Russian attempts to influence the election. Now, those attempts were not made to influence the election in favor of Hillary Clinton. The evidence is clear that the moves by the Russians were to influence the election on behalf of Donald Trump. And Donald Trump himself, during the campaign, asked on nationwide TV for the Russians to reveal anything that they might have on Hillary Clinton, specifically the 30,000 deleted emails. He said, please, Russians, WikiLeaks, anybody, come on and release. And what happened after that was we saw the drip-dropping of Democratic Party information, private information, talking about leaks. We're talking about hacking into Democratic National Committee, DCCC, John Podesta, Hillary Clinton campaign. We saw a hacking into their processes and the dripping out of information that benefited Not Hillary Clinton, but Donald Trump.
Will the gentleman yield?
Not yet. And what we then came to find out is that the Russians have been cultivating Donald Trump for years, encouraging him to run for president. And then the people that the president surrounded himself with on the campaign have contacts and business with Russian interests. And we all know that Russia is corrupt to its core. Billionaires, including Vladimir Putin, and these people running the country like their own piggy bank, getting rich, and Trump wanting to put his name on everything, and wanting to build hotels and put his name on it, definitely susceptible to Russian influence. They tried to help him. So what other influence do they have over him? What are the dealings that he has had with them? Why hasn't he released his tax returns? Might they show some degree of Russian involvement? Maybe some loans through the Deutsche Bank, which has laundered a lot of money. I meant Deutsche Bank. Glad somebody's still awake over there. But, you know, this is a serious situation that demands an inquiry, and the American people are not going to rest until they get to the bottom of this, because they realize that our national security is at stake, is at risk. All that we have built up to this time as a nation is at risk with a guy who could be influenced by a foreign power being on top of the innermost secrets of this nation with his finger, with the nuclear codes at his disposal. It's just too much, and so prudence demands that we get to the bottom of this. I'm so happy that Congressman Nadler has filed this resolution, which I support, and I urge my colleagues to do the same, and with that, I yield back.
Mr. Chairman, I move to strike the last word.
Gentleman from California is recognized for 5 minutes.
Thank you, Mr. Chairman, and I also would like to thank Mr. Nadler for bringing this forward and Mr. Deutsch for his amendment. And what this is about is not politics. It's a statement to the public that our democracy is worth defending. It's a democracy that so many soldiers have defended and sacrificed themselves for on the battlefield for so many years. It's a democracy that so many soldiers right now across the globe are defending. And when they see that another country attacked us, they are looking at us right now and asking, what are you doing to defend our democracy? That's what this is about. And they are asking, what are you doing to get to the bottom of the political, the personal, and the financial ties between Donald Trump, his family, his businesses, and his campaign with the Russian government? Here are the plain facts. Russia attacked our democracy this last presidential election. It was ordered by Vladimir Putin. It was intended to help Donald Trump. Also, most disturbing, if we're looking forward, is that they intend to sharpen the knives and do this again. Our allies, Germany and France, have elections coming up, important NATO partners. But of course, we'll roll into another election shortly. And if we do nothing, we will do nothing but embolden Russia and other foreign adversaries who have similar capabilities to do this again. That's fact one. Russia attacked our democracy. Number two, as was pointed out so eloquently by Mr. Jeffries from New York, Donald Trump really admires Vladimir Putin. It's really bizarre. Either he is the #1 fan, the president of the Vladimir Putin fan club, or something else is going on. But he can't say a single bad thing, even when presented by Bill O'Reilly with evidence that he's a murderer, he's a thug. Instead, our president granted moral equivalence to Vladimir Putin. It's a fact that Donald Trump's family has had extensive business dealings with Russia. It was declared proudly by his own son. It's a fact that Donald Trump wants to reduce the sanctions and has talked about reducing the sanctions, and his incoming national security advisor on December 28 made a phone call to Russia, winking and nodding that the sanctions placed on Russia in penalty for what they did in the election would be reduced.
Would the gentleman yield?
I will not yield yet.
Just for a correction?
I will yield when I'm done. It's also a fact that Donald Trump has spoken openly about reducing the influence of NATO. NATO is the best check against Russia and what they want to do in the Baltics, in the Balkans. That's a fact. He's talked about that. And most importantly, most disturbingly, it's a fact that Donald Trump, for the first time in 40 years, is a president who will not show us his taxes. And my colleague from Iowa said, what would his taxes tell us? Well, actually, there's a part in your taxes called your K-1 partnership shares. And that would tell all of us who are the investors in his businesses. I don't think he's afraid that we will all find out that he's not as wealthy as he says. I don't think he's afraid that we will all find out that he's not as charitable as he implies. It's that we would all find out who he is doing business with. Now, all of those facts I just laid out, if only one of them were true, we could say, sure, Russia attacked us, but this is just a coincidence that Donald Trump's family has done business with Russia, or that Donald Trump admires Russia, or that he wants to reduce sanctions with Russia. But all of them are true. So either all of the arrows point to personal, political, or financial ties with the Russian government, or Donald Trump is the unluckiest person in the world. But we certainly deserve to get to the bottom of this. These dots are all connected. We have a lot of questions, and this is our democracy. And it's fair that we all get to the bottom of these questions and try and connect the dots. And finally, it is not only in our country's interest, it is in our president's interest to have these clouds of questions swirling above his presidency cleared. If nothing's there, this would benefit him more than anything. So, Mr. Chairman, I submit that this is not about politics. This is a declaration that our democracy is worth defending. And with that, Mr. Issa, I would happily yield.
I thank the gentleman. You said that his incoming national security advisor, you actually mean his former national security advisor. You said Russia, but actually it was the ambassador here in the U.S. from Russia.
That's
Is
right.
that correct?
That's right.
Okay, very good.
Move to strike a last word.
Purpose of
And yield
gentleman-
back, Mr. Chair.
For purpose of gentleman from California, seek recognition.
Thank you, Mr. Chairman. I think
Gentleman is
it's...
recognized for 5 minutes.
Thank you, Mr. Chairman. I think it's helpful to take a step back and ask, why are we here today debating a resolution of inquiry into the president? And I think there's at least 3 reasons. And the first and foremost is that we cannot trust the President of the United States. And it pains me to say that. I served on active duty in the military. I have great respect for the office of the president. But we know that Donald Trump lies and makes stuff up. The Washington Post has now fact-checked him, and they did a story saying that in the first 33 days of his presidency, he made 132 false or misleading statements. That sounds to me like a pathological liar. That is not acceptable. President Reagan made the phrase,
Mr. Chairman,
trust but verify.
Mr. Chairman, I'd ask that the gentleman's words be taken down. He just called the president a pathological liar.
That sounds like someone who has made a lot of lies. I'll rephrase it. So President Reagan
The gentleman will suspend. The gentleman can withdraw his words or have
I'll withdraw
them
the
taken
words.
down. Gentleman withdraws his words. He may proceed.
So the Washington Post reported first 33 days of his presidency, President Trump made 132 false or misleading statements. President Reagan made famous the statement, trust but verify. But we're in a situation, right, where we now have to distrust and verify. That's why it's so important that we get these documents, because we cannot trust the executive branch. That's why the legislative branch has to exercise our oversight. Second reason we're here today is because Donald Trump became the first president in history to be in violation of the Constitution the second he finished his oath of office. The framers wrote in Article 1, Section 9, Clause 8 of the Constitution, also known as the Emoluments Clause, to prevent foreign conflicts of interest in terms of foreign payments and gifts, because they understood that the threat of foreign influence on American elected officials was a danger to the Republic. Donald Trump has vast global business holdings all over the world. He can solve this by divesting those business holdings and putting them into a blind trust. He refuses to do so. That's why on my website I created the cloud of illegitimacy clock. You can go on it and see how long he has this cloud over him. As of right now, he's been in violation of the Constitution for 39 days, 5 hours, 35 minutes, 17 seconds. We need to know what his business holdings are if he's not going to divest them, and does he have these holdings in Russia or China, where he just got a trademark after he agreed with the One China policy. These are very troubling issues. And then the third reason we're here today is because we have a known attack by a foreign power, Russia. They did a massive cyber attack last year. You can read the unclassified intelligence report. If you just search for it on the internet, put in unclassified intelligence report, first thing that pops up is this report on Russia by our 17 intelligence agencies. I also read the classified intelligence report. I'm a computer science major. I read it from the perspective of a very technical view, and I can say that there's clear and convincing evidence in my mind that the conclusions of the unclassified report are accurate. And what are those conclusions? They say, first of all, that Russia did this cyber attack. So when the President of the United States says it could have been other countries, he is misleading you. It is Russia. We also know in the conclusions that Russia did it to undermine faith in our democracy, to help Trump, to hurt Secretary Clinton. It also says that Russia hacked into 20 state electoral boards. These are very troubling allegations. So we need to have the source documents. Now, I am pleased that our Republican colleagues are so disturbed by the behavior of the president and his associates that they are going to write a letter to Attorney General. I think that is great. This resolution of inquiry can only help that. There's no reason we can't do both. And if we don't do this, it does suggest to me a fear of too much information. We shouldn't have that fear. We should have the information, look at it, and if there's nothing there, this cloud of illegitimacy over Donald Trump goes away. As an American, I would want that to happen. I hope all of us would want that to happen. So let's seek the truth, see what it says. Maybe it's not a big deal. Maybe it's a monumentally huge deal. And as a legislative branch, we owe it to the American people to exercise our legislative responsibility, to conduct oversight, and to do what the framers wanted, which is to have a separation of powers where we make sure that we are a check and balance on the executive branch. With that, I yield back.
Mr. Chairman.
Chairman.
Mr. Chairman. Mr. Chairman, I'd like to strike the last word. I rise to support the Deutsch Amendment in particular because of its explicit pointing to the Chief of Staff and others who were in the early stages of communication with Mr. Trump. I want to do this from a different perspective. Why I think this resolution of inquiry is so very important. There was an election on, I believe, the first week in November in 2016. That election generated, by the conclusion of the Electoral College, an individual that now serves as the President of the United States. The accusations or the facts did not become transparent to the American people until post the election with respect to details that were easing out. Most of what the American people heard during that election, besides the particular positions of the individual candidates, was emails, servers, which, by the way, were never breached, the former secretary, and lock her up. That was the noise that was leading the American people to the polls. I would have wanted it to be issues on both sides. I would have accepted the election run fair and square. But this resolution is so important. I started out by mentioning the constitutional premise and responsibility of legislation that the Congress has the right to do, and this is legislation. But upon reflection, as I look at Mr. Deutsch's resolution, if I might borrow this for a minute, and I see the individuals who are added to this. Mr. Previs was the head of the RNC. So we have a set of circumstances where we have not answered to the satisfaction of many in this country, was the election legitimate? Did, in fact, a foreign power so skew the election that America's one vote, one person prior to the counting of the Electoral College did not exist? Was there fault? And if so, who, when, and where? This inquiry can generate documents that would answer the questions of no fault. But right now, we have questions about an election and the disparate treatment of candidates. It could have been 2012, it could have been Mr. Romney and Mr. Obama. And if there was something that so tainted what we hold sacred, I believe the questions would have to be asked. This is very different from 2001. 2001 was a question of the votes in Florida. We could have agreed or disagreed, the count. It went all the way to the Supreme Court. You could agree or disagree with them. But I think it should be very clear. Anything that adds to the edifying of our knowledge of whether or not we need to do something to correct the process of elections for a presidential candidate so that we can be sure of the sanctity of that election, we should do. And I would just offer to my friends on the other side of the aisle that if the results were different, if there was any suggestion that another candidate won with the influence of an outside power, how quiet would they be? Not partisan, not political, but they would make the argument that we have a question about the election process. And with that in mind, as Americans, we need to have the answers. So this is getting the answers from the committee that stands in the best position to secure those answers. Documents don't fib. Documents are what they are. That is all Mr. Nadler and now Mr. Deutsch's amendment says, and that is give us the information to begin our review.
The
I
gentleman's
yield back.
time has expired. Any other members
Move
seek
straight left,
recognition? Gentleman is recognized from Maryland, 5 minutes.
Thank you very much, Mr. Chairman. America's a great country, and our founders set it up so we wouldn't have a king in America. That was a radical break from everything that had come before. As the great Tom Paine put it, in an authoritarian society, or what he called an absolute society, the king is law. But in a free society, Paine said, the law is king. The law is king. So what do you mean by that? Well, a king can do anything. A king can make foreign alliances with despots and dictators. A king can decide not to reveal anything about his own personal finances. A king can not submit his tax records. A king can even grab women whenever he wants to. But our Constitution turned all that on its head. Our Constitution began with those three magic words, we the people. All power flows from the people. All of us here in this room work for the people. The president works for the people. The Supreme Court works for the people. All of us work for the people. And in the Constitution, the first article belongs to Congress because we are the lawmaking branch. We are the representatives of the people. And the president's job is just to take care that the laws be faithfully executed. The president is implementing and executing the laws that we adopt. The reason why we have the oversight power, the reason why we have a Judiciary Committee here is because we are responsible for the law, and we can't do it if we don't have all of the information that's available. The great James Madison, from the state of Virginia, from which hails our chairman in this committee, Madison said that popular government without popular information is prologue to a farce or a tragedy, or perhaps both. Those who mean to be their own governors must arm themselves with the power that knowledge brings. We must have the knowledge. That's what the Deutsch Amendment is about. That's what this resolution is about. But our founders didn't just rest in saying we wouldn't have a king. Our founders said that our Congress and our president would not be subject to the will of kings or princes or foreign governments. They knew how we could be financially compromised by foreign emissaries coming over and dangling money and gold and presents. And they said, none of us, members of Congress or president, we're all subject to it, can receive a present, an emolument, which is just a payment of any kind, an office or a title, like, for example, Order of Friendship from a foreign government, from a prince or a king. And yet now we have the first president in American history whose entire administration looks like a money-making operation all over the world. Golf courses, hotels, the Trump Hotel, deals with embassies, foreign potentates coming over, taking out ballrooms, having parties, millions of dollars in and out all of the time. This is America. We're a country that was founded on a rejection of monarchy and being compromised by foreign governments and foreign kings. The gentlemen, with their simple resolution asking for information, are trying to get to the bottom of this so we can vindicate what a great Republican president called government of the people, by the people, and for the people. Despotism's on the march on earth today. We've got a new king on earth, King Putin, the former chief of the KGB, who declared the single greatest catastrophe in the 20th century was the collapse of the Soviet Union. King Putin. So they had the Brexit vote. They had our vote on November 8th, which our intelligence agencies, and let us be very clear about it, told us it was the definitive goal and object of Vladimir Putin and his government to undermine American democracy, not just with espionage and cyber sabotage, but with fake news and propaganda. And, as my colleague from California says, they'll do it again. There's a dress rehearsal for 2020. Next stop is France, where they're putting millions of dollars into Marine Le Pen's National Front immigrant-bashing campaign all over France. Thank God for Germany, the last stronghold of liberal democracy on earth. But our job is to, as Americans, is to get to the bottom of this and vindicate our constitutional values. All of us, Democrats, Republicans, Independents, let's work together and get it done.
Mr. Chairman.
Gentleman's time has expired. No demonstrations.
Mr. Chairman.
Gentlelady is recognized.
Mr. Chairman, I'd like to be recognized for unanimous consent.
Gentleman is recognized.
Chairman, I'd ask unanimous consent that the 2016 financial disclosure reporting by then-candidate Donald Trump, be placed in the record.
Without objection, so ordered.
Mr. Chairman.
Mr. Chairman.
Is gentleman seeking recognition?
Yes, I move to strike the last word.
Okay, the gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This newfound concern about Russian interference with U.S. politics is almost laughable if it weren't so serious. In 2012, presidential candidate Mitt Romney stated in a presidential debate that Russia is the United States' #1 geopolitical foe. President Obama, at the time, looked at him and said, the 1980s are now calling to ask for their foreign policy back because their Cold War's been over for 20 years. There was no reaction by the Democrats at the time, there was no complaint, and there was no request for any kind of investigation. During President Obama's entire presidency, because people need to understand that, and especially you who are here, Russia has been interfering with our elections and with our government for the last 8 years, and with our commerce and with everything that we have been doing. In fact, in 2014, Russia penetrated computer networks at the White House, at the State Department, and I did not hear a peep from the Democrats or the American media reacting with any type of alarm. House Intelligence Committee Chairman Devin Nunes accused President Obama of not taking Russia's cyber threat issues seriously. And the Obama administration and Democrats did not take the threat seriously until President Trump won the election. Hillary Clinton asked to reset relationships with Russia, and none of the members of this committee demanded any investigations. Apparently, they awoke to the threat of the Russians when President Trump won the election. The Democrats claim that they are doing this to defend our democracy. Why were they not defending our democracy during the last 8 years when the chairman of the Intelligence Committee was asking for our democracy to be defended? Finally, during the 2012 election, then President Obama, who was running for re-election, told the president of Russia, "This is my last election. After my election, I have more flexibility." There was no reaction by the Democrats at the time. So somebody asked on the other side, why are we here today? Well, the reality is that Obama and the Democrats did not object because they thought Hillary Clinton was going to win, and they're now upset because she did not win. So this entire hearing is the very definition of partisanship. The only person that we actually have evidence of becoming wealthy off of the government are Bill and Hillary Clinton. And there was no objection about the Clinton Foundation, and there was no objection about them actually doing dealings with other governments and becoming wealthy off of it. I would like to remind my friends on the other side of the aisle that even the New York Times has reported that the officials who have investigated this matter have found no evidence of collusion. And I repeat that, no evidence of collusion. These are the same people that are leaking to the New York Times. They have said on numerous occasions that they found no evidence of collusion. I believe that even the ranking member of the Intelligence Committee said yesterday the same thing, that so far they have found no evidence of collusion. We should allow the intelligence committees to do their job. I actually think we should have an investigation, and that's what the Intelligence Committee is doing. I also believe the FBI is doing that, and I think we should allow them to do their job. If we find any evidence of wrongdoing, I hope that this committee will be the first committee to try to stand up for the Constitution. But it's time to stop playing politics. It's time to accept the results of the election, and it's time for us to get back to the business of the American people. And I yield back.
The gentleman yields back. The gentlelady will be escorted from the room here, please.
Mr. Chairman.
Just a moment. The gentlelady from Washington is recognized for 5 minutes.
Thank you, Mr. Chairman. I move to strike the last word. And I wanted to say that I don't understand why, if the other side is so intent on distinguishing between rumor and fact, that they would not support this underlying resolution. I rise in strong support of the Deutsch Amendment and of the underlying resolution by my colleague, Mr. Nadler, who I think has crafted a very fair resolution, which does not come to any prejudgment. It simply says, give us, the Judiciary Committee, the information so that we can look at what has actually happened. That is the basis of this resolution. And if there is nothing to hide, then let's release the information. Mr. Chairman, I think that the reason that this room is full and has been full the entire day with people waiting for this resolution in the debate and people across the country waiting for this debate to happen is because people do not feel that this Congress, that the Republicans in this Congress are taking this issue seriously. Now, you know, we have, part of the reason for that is we have the chairman of the House Intelligence Committee, Devin Nunes, insisted, he did prejudge. He prejudged. He insisted that there is no evidence that members of the Trump campaign were in contact with Russian officials before the election. And because both Mr. Labrador and Mr. Issa have referenced Adam Schiff, our ranking Democrat on that committee, I want to say that he was misquoted in that it was a fragment of what he said when he said we have no evidence of collusion. The full quote that he gave is that we have, I think, reached no conclusion because we have not called in a single witness or reviewed a single document on that issue as of yet. And when Sean Spicer tried to say the same things that have been said in this committee, Mr. Schiff said that was absolute nonsense. His words are being taken out of context. He told me that I had the liberty to say that they are being taken out of context again because I wanted to check the news reports. So let's be very clear that where we are today is that we have no confidence that an actual independent investigation is continuing. The reason that we are asking for this information in this underlying resolution is because we have a right to have this information. That is how we put to rest whether this is rumor or fact. And Mr. Chairman, the reality is that protecting our democracy and our Constitution is the responsibility of all of us. And when the president, the office holder of the highest office of this land, puts himself above accountability and transparency, it is truly a terrifying time. Now, we have not talked about as much about all of the conflicts of interest, but The Atlantic had a wonderful article that's 32 pages long that documents just a fragment of the conflicts of interest that are there. Now, we have no way of assessing whether these are real or not because we have no documents to look at. We have no tax returns that have been filed, but there are 35 of these conflicts that are here. Now, I submit that there are certain things that all of us on both sides of the aisle should be clear and united on. Number one, that the presidency is not for sale. Number two, that the president, any more than any member of this body, should not be above the law. Number three, that the president should put the interests of the American people first and not the profits, his own profits or the profits of his own family first. And finally, that the president should actually want to prove to the American people that any indications of impropriety should be resolved. He should want to earn the trust of the American people, and I believe that all of us in this body, the Judiciary Committee, should also demand the same, which is why I hope all of our colleagues on both sides of the aisle support this amendment from Mr. Deutsch and the underlying resolution from Mr. Nadler. I yield back.
Gentlelady yields back. Are
Mr.
there
Chairman.
any other members who seek recognition? The gentleman from California is recognized. 5 minutes.
Thank you, Mr. Chairman. I'd ask unanimous consent that an article from the Washington Times in July 12, 2016, entitled Obama Administration Sent Taxpayer Money to Campaign to Oust Netanyahu be placed in the record.
Without objection, so ordered.
Thank you. Now, I'm putting that in the record without further comment. I think it speaks for itself. I also had put in the record 104 pages by May of last year's disclosure by Donald Trump of his holdings. And I think what's interesting is, first of all, it's more pages than I have, which was surprising. I finally found one longer than what I go through to do this. But also, it was a reminder that the United States Office of Government and Ethics has for a very long time, by a law passed by this body and another law, 6103, made two decisions. One was that no one shall involuntarily release their tax records except to a very limited group with limited ability to do it, and a law making it illegal for the House and Senate's Ways and Means and the Joint Tax Committee and the IRS, illegal to disclose those. As a matter of fact, this committee has no right to see the tax records of any citizen in any circumstances and cannot subpoena them. But we do have an extensive reporting requirement under the government ethics requirement, and this requires that every single corporation or partnership or holding and all assets and debts and, of course, income be reported. We have a right to change that reporting. And while I was waiting for an opportunity to speak, I thought back on this body saying no one has failed to release their tax returns. Well, actually, it's a relatively modern decision, goes back pretty much to Gerald Ford. And it is interesting that it's become a political game of who would like to produce their tax returns and then challenge the other side to do it. And it's become a tradition. President Trump made a decision not to do it. Candidate Mitt Romney made a decision to do it, and I watched him be excoriated for every nuance of his tax returns. It's an interesting game.
Yield?
No, I won't. Not yet. Not yet. So what I would suggest to our colleagues who have said a great many things, it is evident to me that many of the things they're saying they want to find, they will find in these financial reportings. And I would suggest that the minority, in concert with the majority, if they want to have greater reporting, not just on President Trump and Vice President Pence, but on all high-ranking federal officers and members of the House and the Senate and high-paid staff, that you're welcome to open up the procedure Mr. Conyers has done for more than 4 decades. I've done for 16 years. All of you in this room on both sides have done. If we think there's further reporting required, I think we should do so. I'm going to close. I'm not going to use all the time. I'll yield to the gentleman. But for 16 years, my family back home has had to deal with a small amount of real estate we own and our foundation. And they've tried to do it, keeping me out of it, because there is a wall that I want to have where I don't want to be in the middle of it. And our first president was one of the richest presidents ever, and if they took his wealth and they normalized it for today, the value of those lands, those extensive lands that go about 16 miles from the Capitol till about half that distance, 8 or 9 miles at least, they'd find out that he was incredibly wealthy, and he had huge holdings, and he fed many of us of that time. And during those battles and during his presidency, he wrote very famous letters, and I suggest you go over to the National Archives and ask to see a few of them, detailing to Martha Washington how to conduct the farm and how to deal with those assets, and tried to give her as much relief as he could while he worked long hours. It is a sacrifice to walk away from your assets, and in the case of President Trump, to make a decision not to run them, but to leave them entirely to your family. So I hope as the dialogue continues, we will at least give credit to the financial reporting, to the fact that he is not the first president of the United States to tell others to manage his affairs.
Would the gentleman yield?
Gentleman's time is expired.
I'd ask him an additional minute so I can yield to the gentleman.
Without objection, 1 minute.
I thank my friend. I just wanted, for the record, since my friend played the role of fact checker earlier in our markup, to set the record straight. My recollection is that candidate Donald Trump did not tell us he was not going to release his tax returns. In fact, what he told us was, I am unable to release my tax returns because I'm under audit. That was false, but that's what he told us. He told us when that audit was complete, he would release them. It was not until he became president of the United States that he then changed his mind and announced that he was not going to release his tax returns. So to be fair, candidate Trump's position on this, I think, while troubling, was at least much closer to where the American people wanted him to be to get that full disclosure than President Trump.
I certainly would agree that candidate Trump did cite an audit as the reason. But of course, he was effectively rewarded or punished by the American people because they didn't have the opportunity to see it. But again, I would like my members on both sides to take note that on 5/16 of 2016, now President Trump did release 104 pages detailing his holdings, his profits, and his obligations. And with that, I yield back.
The gentleman's time has expired. Does any other member seek recognition?
Mr. Chairman.
The gentleman from Illinois is recognized for 5 minutes.
Thank you, Mr. Chairman. And I want to speak in support of my colleague from Florida's amendment, which I support. I strongly support, and I'm proud to co-sponsor this resolution of inquiry. Our founders exercised great foresight in creating the constitutional checks and balances inherent in our three co-equal bodies of government. What was important at the founding of our nation is certainly no less important today. In the context of President Trump's decisions, actions, and possible conflicts, it is probably more important today than at any time in our history. Like many of those who spoke before me, I believe Congress in general, and this committee in particular, has a responsibility to seek full disclosure in pursuit of the truth. The American people deserve, and our system of government demands, assurance that this administration is working in the interests of the people, rather than their own personal or business interests, or even the interests of foreign powers. Furthermore, Congress, as an equal branch of government, must be a critical check on current or potential White House interference into investigations, interference that was already reported just last week. This resolution simply seeks any and all information the Department of Justice has to be shared with Congress on President Trump and his associates, conflicts of interest, ethical violations, potential ethical violations, including the Emoluments Clause, or their ties with Russia. Congress has a responsibility for conducting oversight of the executive branch, and the American people deserve the truth on Trump's potential conflicts, ethical violations, and Russian ties. Finally, this is not a partisan issue. Possible contact between any presidential campaign in Russia and entangling conflicts of interest are not partisan issues. They affect every American and go to the heart of the integrity of our political system. Personally, I would be just as concerned with Russian interference on behalf of a Democratic candidate as a Republican one. And I would be disappointed if my party were blocking investigations into following the truth to wherever it takes us. Nothing has been prejudged. We can't make judgments without information. But the American people, my constituents, are calling for us to have that information, and this resolution calls for that information, and that's why I support it. Before I yield back my time, I would like to yield some time to my colleague from Florida, Mr. Deutsch.
And I thank my friend from Illinois. Our colleagues on the other side of the aisle have questioned our intent, they have questioned our politics, they have even questioned our mental state in moving this resolution forward. I would just simply suggest that we all take a deep breath and look at the words and look at what we're trying to do. And I would ask my colleagues to go through each of these. All we are asking is that the Attorney General deliver to us any information that he has about criminal or counterintelligence investigations targeting the President, Mike Flynn, Paul Manafort, Carter Page, or Roger Stone. I don't see what the objection could be to that. We've asked that the Attorney General, if he has the information, provide to us that information as it relates to investments by any foreign government or agent of foreign government in entities owned by the President. I don't see what the objection is to that. It says that the Attorney General should give us any information about that he has about the President's proposal to maintain an interest in his business holdings, which cannot be objectionable. We ask that the Attorney General turn over any information that he has about the President's plan to donate the profits of any foreign government's use of his hotels to the Treasury, including the decision to exclude other payments by foreign governments to other business holdings of the Trump Organization. I don't know what the objection is to that. And we ask that the Attorney General turn over any information that he has with respect to the President or any employee of the executive office with respect to the Foreign Emoluments Clause that binds the President just as it binds every one of us. And finally, this requires that the Attorney General turn over to us any information that he holds about the possible violation of statutes governing conflicts of interest, which I don't understand what the objection is.
The fact is, while my friends have criticized us for playing politics, questioned our intent, our motives, our mental state, the fact is that it is inconceivable that there could be an objection to any one of these. And Mr. Chairman, I would, to that end, suggest that should this resolution fail today, that we simply request each and every one of these items in a letter to the Attorney General, and that we put an outside date by which he delivers it to us, and if he fails to deliver it, then bring the Attorney General here and let him sit at that table in closed session, if need be, to answer all of these questions, because the American people deserve to know.
The question occurs on the amendment offered by the gentleman from Florida. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Being the chair, the noes have it. The
I ask for a
amendment is
recorded
not agreed
vote.
to. A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Yes. Ms. Lofgren votes yes. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Gutierrez votes aye. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell?
Aye, 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 aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Aye. Ms. Jayapal votes aye. Mr. Schneider?
Aye.
Mr. Schneider votes aye.
The gentleman from Ohio.
Mr. Shabbat votes no.
The gentleman from Arizona.
Mr. Franks votes no.
The gentleman from Texas. The other gentleman from Texas. The gentleman from Florida. Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 15 members voted aye, 18 members voted no.
And the amendment is not agreed to. Are there further amendments to House Resolution 111? For purposes of the gentleman from New York, seek recognition. Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.Res 111 offered by Mr. Jeffries. Page 2, line 16, strike "and" at the end. Page 2.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you.
Thank you, Mr. Chairman. This amendment asks the Attorney General to transmit copies of any document, record, memo, correspondence, or other communication of the Department of Justice, including the Office of Legal Counsel, that refers or relates to the application of law governing when it is appropriate for the Attorney General to recuse himself. Under 28 CFR 45.2, titled Disqualification from Personal or Political Relationship, employees of the Department of Justice are not to participate in a criminal investigation or prosecution if that individual has a personal or political relationship with the subject of the investigation. A political relationship is defined as a, quote, close identification with an elected official, a candidate, whether or not successful for elective public office, a political party, or a campaign organization, arising from service as a principal advisor thereto or principal official thereof, close quote. Applying these standards, past attorney generals have found that it is appropriate to recuse oneself not only in circumstances where there's an actual conflict of interest, but where there is an appearance of conflict as well. The choice to recuse oneself is not indicative of wrongdoing in and of itself. In many cases, it's simply the mark of sound judgment and commitment to the duty of the office. Mr. Sessions was a staunch supporter of Donald Trump throughout his campaign, a prominent member of his transition team, and now serves as his appointed Attorney General. His ascension is inextricably linked and tied to the President of the United States. Sessions was the first senator to endorse Donald Trump. Throughout the campaign, Sessions attended numerous rallies for Trump, acted as a surrogate for Trump on television interviews and at events, and served as an advisor on a variety of issues. In March of last year, the Attorney General, then a senator, was named the chairman of Donald Trump's National Security Advisory Committee. In the months following that appointment, Jefferson Sessions seems to have changed his long-standing views on the threat Russia poses to the United States. Back in 2014, Senator Sessions, following acts of Russian aggression in Ukraine and Georgia, called for sanctions against the Kremlin, saying that, quote, a systematic effort should be undertaken so that Russia feels pain for this. However, during an interview with CNN in July of 2016, he said, Donald Trump is right. We need to figure out a way to end this cycle of hostility that's putting this country at risk. And that the big issue is, should we be able to create a new and positive relationship with Russia? All of a sudden, he changed his tune. In Sessions' confirmation hearing questionnaire, when asked about the circumstances under which he would recuse himself, Sessions wrote that if a specific matter arose where he believed his impartiality may be reasonably questioned, he would consult with the department ethics officials and would always be fair and work within the law and established procedures of the Department of Justice. In this vein, he stated that he would recuse himself from investigations into Secretary Clinton, recognizing that statements he had made during the campaign would place his objectivity into question. If you would recuse yourself from investigating Hillary Clinton, the same logic applies to Donald Trump. As a senator, Sessions demanded the same of both of Obama's attorney generals. Days before the 2016 presidential election, he wrote a column arguing it was time for Attorney General Loretta Lynch to appoint a special counsel to investigate former Secretary Clinton's unsecured email server. He wrote, when a high public official is accused of serious wrongdoing and there is a sufficient factual predicate to investigate, it is imperative the investigation be thorough, with dispatch, and without partisanship. The appropriate response in a highly charged political atmosphere is for the Attorney General to appoint a special counsel of public stature. That was his standard for Hillary Clinton. It should also be his standard for Donald Trump. And I ask my colleagues to support this amendment.
The chair recognizes himself in opposition to the amendment, and I urge my colleagues to oppose it as well. Again, this amendment seeks to broaden the scope of this already overly broad resolution and seeks any documentation in the possession of the Department of Justice relating to the application of the Code of Federal Regulations to the Attorney General's relationship with the President. Just as with the other amendments, this is based on nothing more than a supposition that there may be something improper there which could be used to damage the administration politically. My colleagues on the other side of the aisle have consistently stated they are seeking the truth, but in reality, this is little more than a fishing expedition based on unfounded allegations and designed to delegitimize a president who has been in office for all of 5 weeks. This is not the way to conduct oversight. There is a better, legitimate way to do so. Just as we did with the previous administration, this committee will act appropriately. And I would point out that when the assertion was made earlier that we were all about the investigation of Hillary Clinton, it should be noted that it wasn't until the Federal Bureau of Investigation's director made a public statement that the investigation was concluded that we then called for him to come before this committee and explain himself, particularly why he was the one making that decision and not the Attorney General of the United States, who had compromised himself by going on board an airplane with the Democratic candidate's husband, the former president, thereby compromising her ability to make an appropriate decision about whether or not a prosecution should have taken place there. That would be the appropriate time. That would be the appropriate time to request all of the things that are being requested here of the Department of Justice. Not at the outset, not at the time when the FBI and the Department of Justice would be beginning an investigation. These requests could compromise that investigation, not help it, and therefore I oppose this amendment, and I believe that the Attorney General of the United States should be allowed to do his job.
Mr. Chairman.
What purpose does the gentleman from Michigan seek recognition?
I support the resolution of the gentleman from New York.
The gentleman is recognized for 5 minutes.
I think this is an important modification to the Nadler resolution, and I commend Mr. Jeffries for bringing it forward. The regulation that he cites in his amendment is quite clear. The Attorney General may not participate in a criminal investigation if he has a personal or political relationship with any person substantially involved in the conduct that is the subject of the investigation. According to the regulation, a political relationship is a close identification with an elected official, a candidate for elective public office, a political party, or a campaign organization arising from service as a principal advisor thereto. And in this case, Attorney General Sessions was one of the earliest supporters of President Trump, campaigned with him, and even served as a senior advisor to the president both before and after the election. If indeed the FBI is investigating the Trump administration with respect to any of the items listed in the underlying resolution, then Attorney General Sessions likely has an obligation to recuse himself. And if those conversations are taking place, then we as members of the committee with oversight responsibility for the Department of Justice have an obligation to ask the department for basic information about their legal analysis here. And so this Jeffries amendment is an important addition to this resolution, and accordingly I urge its adoption.
Would the ranking member yield?
Of course.
Thank you. I too support my colleague's amendment. I also think there's a responsibility when President Washington is invoked to make sure that we understand the comparison here. We all know who George Washington is. We all are here because of his sacrifices, resigning his commission to the Continental Congress, not serving beyond 2 terms. I'm sorry to my colleague from California, but Donald Trump is no George Washington. In fact, he had an opportunity to make a sacrifice when the Wall Street Journal called on him on November 18, when they said, President-elect Trump should liquidate his stake in the family business. One reason 60 million voters elected Donald Trump is because he promised to change Washington's culture of self-dealing. And if he wants to succeed, he's going to have to make a sacrifice and lead by example. These amendments are important because we have seen no sacrifices and only conflicts from this president. And I would
Gentleman yield.
I would yield back and should ask him to yield.
Would the gentleman yield?
Be pleased to yield to the gentleman from Maryland.
My thanks to the ranking member. I would just take it one step further than my good friend from California. Our first president was invoked in the context of a series of statements that members on this side of the aisle made about the Foreign Emoluments Clause. So when you make the point that George was in constant contact with Martha about the management of the estate, I think it's a bit off point. Martha Washington was not a foreign king, prince, or government. Martha Washington was his wife and an American citizen. And so I think you're going to have to search harder through the history of American presidents to find one who launched his presidency with an international business empire and refused to divest himself from it, and refused to create a blind trust, and rather continues to be involved in ways known and unknown in the management and participation in those business affairs. And really, the accusation that we're somehow being political, it takes me up short. None of us wants to be overly political. I understand that there's a certain reservoir of hypocrisy that sloshes back and forth, you know, during different administration changes and so on. But are you telling me that if Barack Obama had hotels and had golf courses and business interests all over the world, that you would not be interested in determining whether there's a violation of the Foreign Emoluments Clause? Are you telling me if Barack Obama said the kinds of things about Vladimir Putin that Donald Trump has said, that you would not be interested in getting to the bottom of that relationship? That defies my ordinary ability to believe. I yield back, Mr. Chair.
Mr. Chairman.
Mr. Chairman.
I yield back.
Mr. Chairman.
The gentleman from California is recognized.
Chairman, to strike the last word.
I was recognized for 5 minutes.
Since the gentleman brought up our first president again, I thought we'll continue the professor's learning experience here. You're right. Martha Washington was an American. All of the Trump family are Americans. The president has made a decision to turn over the operation of his assets to his family. That's very consistent, and I'm sure the gentleman from Maryland would agree that that is, in fact, exactly the same thing that President Washington did, except President Washington actively managed through letters. So I would hope that the gentleman sees that. I also would like to caution the gentleman. I put into the record a while ago 104 pages from President Trump's then last filing. He'll have to make one every year. I looked through it. I didn't find any holdings in Russia. I didn't find any corporations that, as far as I can tell, are there. I didn't find any liabilities to Russian entities. Now, if the gentleman goes through those pages and others and finds it or believes that it's there, then that's very different than asking for his tax records, which wouldn't tell you anything more than the financial holdings. So I would hope that we could have an honest debate. I know the gentleman wants to have an honest debate. I am on record, and will continue to be on record, saying this committee and every committee of jurisdiction needs to be very concerned about foreign countries, or the allegation of foreign countries attempting to influence our elections. And that especially would have the evil mini-empire known as Russia and the evil killer of his opponents, Putin. So you've got a total ally in me. But I do think that we have to limit ourselves to what we know, what we can know, and what we need to know. And I, for one, would say that many of the things you said are in fact true, but when it comes to the historic people who have had money, they do not turn them over. Turning over to blind trust a bunch of mutual funds may be easy. Turning over active businesses that need to be managed are not. And I do think that the decision made by the president, if legal, and I believe it is beyond the scope of what we should be talking about here. We should concentrate on the fact that over the last several years, the Russians have attempted and succeeded in interfering with elections around the world. They have invaded their neighbors. They have, in fact, killed people. They're famous now for the little green men who are actually Russian soldiers who come in to invade another country. We should be concerned about it, and in this case, we need to get as much cooperation from the Attorney General. And I, for one, want to move toward the Attorney General voluntarily giving us information, and if he doesn't voluntarily share appropriate information, then call him to this committee. We did that under the last president. I would expect to do it under this president. I'm going to tell you one thing right here. I'm not voting for this resolution. I intend on voting against it. But I also intend and will continue, and my chairman knows this, to push all the committees to look at everything in the way of waste, fraud, and abuse in government, and certainly to keep an eye on the ethical handling of all affairs by the president, the vice president, and every cabinet member. And I thank the gentleman for the time, and I yield.
Would the gentleman yield
back?
Mr. Chairman.
For purpose of the gentleman from New York.
Strike the last word. Mr. Chairman, as this debate comes to a close, I'll be very brief. I just want to say with respect to this amendment that all it does is request information with regard to recusal. It was Mr. Issa who quite properly pointed out that the Attorney General had not recused himself and drew some appropriate conclusions from that. I commend them for doing that. This amendment, which I support, simply asks for any information about recusal. The underlying resolution, which I authored, simply asks for all relevant information to be given to this committee so that we can do our job. And that's all it really does. And all of our suspicions, and some people are more suspicious than others, will be more informed and perhaps less suspect, or perhaps more suspect, when we get the information. Information we ought to have. I'm glad to hear that the chairman is composing a letter. It'll be interesting to see that letter, to see how complete it is, maybe to sign it and to join it. But meanwhile, we ought to pass this resolution in order to get the information that we can get. I thank you, and I yield back.
For purpose of the gentlewoman from Texas, seek recognition.
I rise to support the Jeffries amendment.
Gentlewoman is recognized.
Just
5 minutes.
Commend the gentleman for his thoughtful presentation. I thought that he was particularly pointed in the analysis of which he used. This is not a questioning of a personality. This is recognizing the integrity required, transparency required of the chief law enforcement legal officer of the nation. It has been well documented that the Attorney General is not the counsel of the President. There is a White House counsel. We've seen incidences that have required the independence of the Attorney General, for example, Elliot Richardson, during the Nixon administration. I think this is an important addition to Mr. Nadler's very thoughtful amendment, because just a few weeks ago, the Deputy Acting Attorney General, or the Acting Attorney General, Deputy Attorney General Sally Yates, had to march to the White House to indicate that the former NSA Director, General Flynn, had lied to the Vice President. What is required is complete, impeccable ability to be able to see and call it as it is, without a reflection on anyone who serves in that position at this time. It is clear that if you have befriended the General, the President, if you were part of the transition team, you've advocated and counseled him on immigration issues and other issues, there is a close intimacy that raises the question of making sure that you, the Attorney General, acknowledge yourself whether or not there's anything that would suggest that you could not be fair and transparent. So I thank the gentleman, Mr. Jeffries, for offering this particular amendment to the resolution. And as I close, Mr. Chairman, a moment of personal privilege to acknowledge Chief Michael Durden, who is here from the Houston Police Department, who's been sitting here with us all day, who knows Judge Poe. Stand up, Mr. Durden, or Chief Durden. Since we have the police working group, I just want to acknowledge, unfortunately, Chief Durden is away. We had 2 officers who were shot in Houston, and he is monitoring their condition. Thank God they have survived, and they are both in the hospital. But I want to thank Chief Durden on behalf of all of us for your service, and certainly on behalf of the Houston Police Department for your service to the Houston Police Department.
Would the gentlewoman yield?
I'd be happy to yield.
I thank the gentlewoman for introducing the chief, and would tell the chief that we are hoping to visit Houston very soon with our policing strategies group, and I look forward to that occasion, and we'll see you there again.
Thank you. Thank you very much, and I yield back my time.
Question occurs on the amendment offered by the gentleman from New York. All those in favor respond by saying aye. Aye. Those opposed, no. Opinion of the chair, the noes have it, and the amendment is not agreed to. A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Mr. Gutierrez votes yes. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Gentleman from Ohio.
Mr. Jordan votes no.
The gentleman from Texas.
Mr. Farenthold votes no.
The clerk will report.
Mr. Chairman, 15 members voted aye, 16 members voted no.
And the amendment is not agreed to. The question is on the amendment in the nature of a substitute. All those in favor respond. Gentleman will state his inquiry.
I just want to clarify for the members that we're going to have 2 votes now. One is on the motion to substitute, which is a technical correction in effect, and I don't think anybody is going to object to that. And then we will have a motion on the underlying bill as substituted for, which your motion will be to report unfavorably, and therefore those of us who support it will vote no, and those of you who oppose it will vote yes. Is that correct?
That's correct.
Then let me simply commend the chairman for not exercising his prerogative to move the previous question.
I thank the gentleman.
On this bill.
And I thank the members on both sides of the aisle for moving this reasonably expeditiously. The question is on the amendment in the nature of a substitute. All those in favor respond by saying aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on reporting the bill unfavorably as amended. All those in favor respond by saying aye. Aye. Those opposed?
No.
In the opinion. The clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes yes. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson Lee? No. Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Mr. Gutierrez votes no. Ms. Bass? Mr. Richmond? Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no.
The gentleman from Ohio.
Mr. Shabbat votes yes.
The gentleman from Wisconsin.
Mr. Sensenbrenner votes aye.
The gentleman from Arizona.
Mr. Franks votes aye.
Has every member voted who wishes to vote? The gentlewoman from California.
No.
Ms. Bass votes no.
The clerk will report.
Mr. Chairman, 16 members voted no, 18 members voted aye.
The ayes have it, and the bill as amended is ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. It's been a long day. I appreciate the participation of all the members, and the meeting is adjourned.
Thank you.
Thank you.
Good job. Good job.